May it please your lordship,
Yes.
with due consent of the other side, I beg to mention item number 17 of the daily list, my lord. 17. Conducting counsel, Mr. B. Chaudhary is indisposed as on today. I'm praying for 2 weeks' time, my lord.
Okay.
17.
Uh,
17,
Whole pending matter 2015.
my lord.
Okay. Learned Standing Counsel for the Finance Department has sought for an adjournment for the reason of personal difficulty of Mr. B. Chaudhary. First of prayer is not objected by the learned counsel for the petition. First of accordingly, same stance allowed. List this matter. Any urgency? No. List this matter after 6 weeks.
My lord, Finance and Taxation Department.
Finance and Taxation. Standing Counsel, Finance and Tax. Yes.
Highly obliged, my lord.
May it please your lordship. Lordship, I beg to mention item number 4, my lord.
Yes.
My lord, in this case, my lord, was fixed on 18, my lord, in the trial court, my lord. But we could not obtain instruction what happened in that court that day, my lord. Kindly adjourn the matter for today, my lord, and fix another date on next
Okay.
week, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed. Next week, give a date.
Next.
Wednesday, up to Wednesday, I will be in adjournment.
Next Thursday.
No.
Next Thursday.
Obliged.
First.
No problem. Yes, next. We should call for it. Yeah. Continuously go Matish.
7.
Wait
Seven.
first.
7.
Yes, sir.
Yeah.
What is the
Yeah.
instance?
Yeah, follow the 7 1 report has come there, but on the last looking,
Uh-huh.
kindly please.
Understand
last
that
one.
he's
Whether he
saying
can
that
visit,
bedridden and all.
he said he is, as per the statement of the, my lord, reply of the IO, my lord. He said that he can visit the IO, the residence and take the statement,
Okay,
my
so
lord.
we'll-
So my,
okay.
yes, man, and it can be fixed after some days, my lord.
So we'll fix a date for Kesdari later on. Let his statement be
Yes,
recorded. Okay.
yes.
In terms of this court, in terms of this court's order dated 18/7/2024, Mr. Goswami, learned additional public prosecutor, from on the basis of instruction from the IO of the case, submits that IO will have no difficulty in visiting the residence of the petitioner to record his statement. Full stop. In view of the aforesaid, the present IA stands closed with a liberty to the IO to visit the residence of the accused and record his statement in his residence for the
Right.
reason of petitioner being in a bedridden condition. So
Yes.
IA stands closed. Herit likhibo. In view of a bit. In view of order passed in IA Criminal 6/2022 of 2024, let this matter be listed.
He is from Jorhat, my lord, to go after 3 weeks.
After, give a date after 3 weeks. 28th of August 2024. Interim order passed earlier shall continue. Full stop. The condition of petitioners appearing before the IO stands dispensed with in view of the order passed in IA Criminal 6/2024. First.
8.
In item 8, Lordship, Mr. Dilip Mozumdar, additional AG, he is appearing. He is out of station today. So he asked me to day after tomorrow.
Objection is filed.
Yes.
Objection filed. Okay.
Day after tomorrow.
Day after tomorrow.
Lordship.
Okay. Ask him to be ready. We'll see the matter also.
Once the entire matter can be heard.
Heard, yes.
Lordship.
Not day after tomorrow. Day after tomorrow is Thursday.
Thursday,
Next Tuesday.
next Tuesday.
Next Tuesday. On the prayer, Mr. H. Sharma, learned counsel for the petitioner, submits that this matter is being argued by Mr. D. Mozumdar, learned additional advocate general, who is out of station today. First up, accordingly, he prays for an adjournment. Prayer is allowed. Prayer is not objected. Most of accordingly, same is allowed. List this matter on
Matsudal.
Yes, Mr. Talukdar.
My lord, the
Any
minutes-
development?
Yes, my lord, the minutes of a meeting of the government, my lord. I want to place before your lordship. Basically, basically, এখন page তলত চাওকচোন। তলত page এখন extra page এখন বেছিকে গৈছে নেকি?
2 pages. Here are 2 pages.
2 pages.
Okay.
কোনটো লৈ আছে? এইটো 10 ৰ পৰা 13। 9 টো কোনো এপ্লাই কৰা নাই, সেইকাৰণে কোৰ্টে ক'লে ন?
This will be a never-ending process.
My lord, I am told of the records that the file is before the CM moment, Chief Minister Office. So perhaps it is indicated in the minutes also at the highest level that expression is used. So I leave it to your lordship, my lord. But for the last time, I think, my lord, the time should be granted because a cabinet decision may be necessary. Because at the principal
We
secretary,
understand, but
Yes.
that can be a ground in contempt also.
Correct, my lord.
We thought that the state machinery will a little bit move faster. But then I'm not taking that bench also, keeping unnecessarily diseases parted.
My lord,
We are doing this for today,
Yes.
but without any development, it will be difficult to go on monitoring. Instead, we decide the matter. The matters are decided. They are having right. Up to Supreme Court, you have failed. So simply we'll have to pass an order. Our anxiety was that ultimately contempts are pending, nothing has been done. Putting somebody inside jail will serve no for this purpose. And this executive cannot pay money without state's intervention. That is also clear.
my lord, I concede.
They will say this is not willful
Correct.
disobedience. What should I? These issues are there, but
Lordship, that is why the contempt matters should not have been segregated, Lordship. It should have been.
but this was a prayer. What to do?
Lordship, not my prayer, Lordship.
No, understand. We thought that if these matters can be resolved for years, this is a major chunk of litigation in this court.
Lordship,
How many contents we do not know are pending on these issues up to Supreme Court, and they will come and say this is not willful deliberation, disobedience. We cannot.
Lordship, I understand. That is why, Lordship, we wanted those matters to be taken here, Lordship.
May I also point out one thing, my lords?
Give the file, 10 today, not this. 10, 11, 10 to 13. Pass order in Archbishop. Item number 11, huh?
Your lordship has been passing in 404.
404 is item number
11.
11, that is employees
my
cooperation.
lord, my lord.
Lords, may I also just point out one thing?
Yes.
There is an order of 30th June 2022.
Hmm.
Lords, a audit team was constituted by an order of this honorable court, my lords, comprising of the principal accountant general and the director of local audit funds. Well, their task was to verify the transactions and the book of accounts of all the branches. But that would have what that exercise was intended to do, my lords, was to find out what the assets of the bank are, what the financial transactions are.
Just
Yes.
before you
My lords,
further proceed, see, I've seen all those things. Even some seizure of documents, CID inquiry.
Now a report was to be placed before my lords, my lord. That has not
Suppose
been.
reports is placed. Suppose that, and it comes that there are mismanagement, money are misutilized. What you expect from this court to do?
That clarity would be there, my lord, as to what the
No,
financial.
suppose
status
there is a
there.
clarity. Will you
It will
serve your purpose?
Perhaps not, yes.
Not perhaps, it is not, it will not. At the same time, we are not in a PIL to direct some inquiry, this, that. So we'll have to exercise our power within our bounds. So that's why that we can pass many, but ultimately CID inquiry subject to due respect to those orders. CID inquiry, then seizure of documents, that will complicate the issues.
Because that audit has already.
We cannot say revive this pendants.
With
These
that
are
also.
financial issues. What we can say is that this due, pay them. That order we can pass today itself. But we have seen the fate of these people. For years, contempts are pending. We were also helpless. We cannot say pay. We can send them to jail for 6 months. Ask them to stand in the court for the day. Matter ends there. We want our orders to be implemented. We are trying in a different way. So, item 404. Pursuant to this court's order dated 25/6/2024, Mr. S.K. Talukdar, learned counsel, has produced minutes of the meeting held on 20/07/2024 as regards
Presided by Principal Secretary, Lordship.
matters of meeting regarding escort in the bank in question, presided over by the Principal Secretary, Cooperation Department. Full stop. Cooperation Department. Anybody from the association? No, no.
No.
Okay. Headed by Principal Secretary, Cooperation Department. Full stop. The Chief Executive Director of the Escort Bank was also part of the said meeting. From the meeting, it reveals that the final decision as regards revival of the Escort Bank as a revival proposal submitted by NAPCONS. What is NAPCONS?
NAPCONS is a consultant of NABARD.
Okay, no, NAPCONS, a consultant of NABARD, is pending before the highest authority for a final conclusion. Full stop. A final consideration. Mr. Talukdar further submits that a cabinet approval shall be necessary in
Maybe
this
necessary.
regard.
Maybe necessary.
May be necessary. It will be necessary. May be necessary in this regard. And as per his information, matter is pending before the Honorable Chief Minister.
My lord, that may not be. Because I have heard, because that expression is avoided, my lord, there. My lord, I may be seeing, lord, in some, my lord, inconvenience. So lordship may.
Okay,
my lord.
okay, no, comma, full stop, full stop. And the matter is at present is under consideration of the highest authority of the state,
Statement, correct.
highest executive authority of the state.
That will be, my lord, more convenient. But
Authority of the state. In view of the above, Mr. Talukdar submits that if the matter is adjourned today, he would be able to apprise this court the further development in this case. Full stop. This, full stop, next paragraph. The present repetitions involves claim of salary / pensionary benefits, etc. by some of the employees of the Escort Bank, erstwhile Escort Bank, not erstwhile Escort Bank, full stop. As well as Escort Bank, full stop. It is brought to the notice of this court that there are many orders directing payment of such arrears of salary, sales, pension, and reinstatement of employees in the bank, service of the bank. Full stop. And contempt petitions are also pending before this court. In that background, this case was kept as part heard by this court so as to ensure that the orders passed by this court are implemented and the rights of the petitioners are protected. Full stop. At that stage, the proposal for revival of the bank was brought on record. Full stop. In the aforesaid background, as a last, will not say last, in the aforesaid background, the prayer for adjournment is allowed. Full stop. However, it is made clear that if nothing progresses, this court may decide the individual writ petition on its own merit on the next date fixed. Full stop. List this matter on.
3 weeks, my lord, so that everything, my lord.
Let it be 4 weeks.
4 weeks, my lord.
Okay, along with the contact. These at least my part, Lordship.
See, there is an order of releasing the contempts on the request of the learned counsel for a petitioner.
Let it come in this court, Lordship. Then your Lordship will know what.
No, we'll do on the next date. Let us see. If ultimately it gives, your contempt will otherwise be. Let us wait for some time. A copy of the minutes of meeting dated 27/2024 within Supra is kept on record.
And wait for a fixed date.
Fixed it.
4 weeks, Divo, huh?
27th of August.
Would it be, my lord, subject to my lord's
Huh?
convenience, my lord? Would it be after 30th August, my lord? So possible?
Can it be a little bit prior, before the 4 weeks expires? Because by notice, 27 মান আগত দিয়া 25 মান আজি কিমান তাৰিখ
16th August, my lord, if possible.
16th August, not 16th, after, let it be 22nd.
I will not be, my lord, any possible.
No issue. Yeah.
22nd.
এইখিনি কেইটা মানে অৰ্ডাৰ আছে এক কৰি দিয়া নাই ন ৰিকল কৰা মাতি দিয়া লেফট ওভাৰ Yes, Mr. Chaudhary.
Yes.
What is this IA?
Lord, basically, IA as well
Yes,
as the
tell
main
us.
writ petition can be considered.
Lordship, my senior is in out of station, Lordship.
Who is your senior?
A guy, Lordship.
I think this matter,
C appears as a CGSC, my lord.
now who is the main
Oh.
who is the main respondent, contesting respondent?
NMBA,
No.
Nectar, Customs Department, CGSC.
Basically,
my lord-
basically this exemption and all is not it.
Exemption-
Exemption.
And my lord, there is a recommendation by the Chief Commissioner.
Hmm.
Because if your lordship will kindly permit me to place
I've
one.
gone through, but if they are not ready, then it will be a difficult proposition hearing. I thought this.
But this Gayan appears for a respondent who doesn't matter actually, it is CGSC who matters.
Who is CGSC?
Mr. Kyle,
KL
Well,
appears.
I don't have any difficulty, but see, Mr. Sudhiri, half-hearted we do not want to do it.
My lord, may kindly fix a date, my lord.
We'll fix it, no problem, because this matter is pending since long.
Yes.
If he gets it, if he'll get it, if not, it is not, that's all.
Next Tuesday.
Next Tuesday, and we have fixed another
Or
series.
Thursday.
Thursday?
It will not take long, my lord. It's a
Huh.
very short matter.
one of the point is that.
Actually, what had happened, my lord, we were given customs duty exemption. We had a corresponding obligation of making export.
Hmm.
Now, what had happened, my lord? Originally, this bamboo blinds and curtain, China was the leading player. Then when countries like Vietnam, India also started, what China did, my lord, they reduced the price of their product. As a result, my lord, our products could not be sold in the international market. But that aspect was noticed by the government of India. That's why the Chief Commissioner of the Customs and Central Excise specifically recommended to the government that the waivers should be given. That is the only case. Because as per the condition, we are supposed to see.
What is their stand?
No, they have not, the government of India as such has not disputed our claim.
Now, what about this IA, why? this-
IA, we filed the
No
IA.
course of
so
action.
that- Yes,
That is there already.
same thing. Minister.
We don't want.
This matter should be disposed of.
Yes,
Who is your senior? A Gayan.
Again,
When will she be here?
by tomorrow, Lordship.
By tomorrow, next Thursday, if possible, in return. Or thereafter, next week, Tuesday,
let it be next Thursday,
next, not this, not,
next Thursday.
meaning thereby date,
Date would be, my lord.
1st of August,
Yes,
1st of August. A Gayan, beach will be ready on 1st of August.
Okay.
Deep-
May I please, Your Lordship?
Yes,
Before starting, Lordship, I have one prayer, Lordship. In this case, in terms of order dated 15/5, Lordship, Revenue Department is to file affidavit, and accordingly they have filed, Lordship. But copy of that affidavit, two affidavit in both cases, Lordship. I have one case supplied last night at 8 PM, Lordship. So, and in one copy I have not received, Lordship. So I have to take instruction, Lordship, in respect of that affidavit, Lordship.
That is not the part, Lordship, because in this case, what happened, Lordship? The affidavit, what happened, the government, because since the matter is of 2015, Lordship.
you understand?
Lordship, matter is 2015, but NHIDCL is implemented in the year 2023 now. Lordship.
No, that's it. So, in this case, let's
Who,
first,
who will pay the amount?
Lordship, that is to be decided, Lordship. NHIDCL, whether NHIDCL or by the state government.
This is one. Then they are saying that they are entitled for higher in
as per
terms
the
of
new
the new
as
act.
per the new act.
New
Yes,
act.
Your Lordship.
So we'll have to decide as per the new act or old act.
Whether it is lapsed in terms of, yes, Lordship, that is to be decided.
So,
So, but
Lordship,
in the affidavit in opposition, Lordship, the Revenue Department has filed one affidavit, Lordship, in paragraph 4, Lordship. That
What
it
is
is to
your
be paid by the NHIDCL because land was handed over to the NHIDCL, Lordship. That is why.
What was the purpose of the construction? What was the purpose of the acquisition?
Lordship, purpose of the acquisition, Lordship, I know, Lordship, but
No, what was the purpose? I'm asking it. I do not know. What is the purpose?
for construction of NH national.
Construction of national
Lordship,
highway.
earlier, it was acquisition by the state government, Lordship.
No, we are saying one thing. Okay, we'll adjourn it, no problem
Yes,
on it, but we will be jobless for whole of the day.
Yes, yes.
All matters are adjourned. Here issue is, suppose either way. Admittedly, this land was acquired for construction of national highway. Now issue is whether the earlier act or the new act,
New act.
applicability of the earlier act of new act. Now you have asked the state to acquire. You are the requiring authority, you have asked the sir. Yes, suppose state has committed a mistake, assuming for a moment, we are not going to the details, assuming for a moment that state has committed a mistake. Now, will that mean that land acquired for a national highway, state will have to pay the extra compensation? Is it law?
Lordship, since
Ultimately, you are for whom you are the person, they are only acquiring authority.
Lordship, initially that land was acquired by the state government, Lordship.
Acquired for what?
For construction of national highway, Lordship.
Huh.
But in thereafter, Lordship, Minister for Transport and Highways, Lordship, decided to hand it over to the NHIDCL, Lordship, in the year 2015. And accordingly, on 9 September 2023, Lordship.
Now you want to say that when land was acquired, it was not
Lordship,
the
at that-
National Highways Authority who had the responsibility to construct the
Lordship,
highway.
my submission is, Lordship, after publication of the Gazette notification, it was, Lordship, state government, land was of the state government. And after handing over the aforesaid land to the NHIDCL, Lordship, since the matter was state government, matter was of the state government, Lordship, so it is, we have not to pay, Lordship, free of cost, Lordship, as per our act,
Okay, what is your proposal today?
Lordship.
What do you want today?
Lordship, I want, Lordship, since I want some instruction of that in respect of the affidavit filed.
You have already argued on that instruction. You have made your argument on that instruction.
Also, can you see the order dated 16?
Okay, if a notice has been, there is a bearing upon,
that-
bearing upon
As per the
NHIDCL.
new act or old act, that has been decided.
Hmm.
Now who they pay the compensation, only that part. Now what happened?
So therefore, if he wants to respond to the affidavit of
Yes.
the state, if it is served on him yesterday, I think he will
Yes,
have a,
Lordship.
at least a,
Yes,
Last-
definitely they should have a instruction
because they are,
now they are playing the ball from one side to other side.
no, we'll
Ah.
catch the ball in the midway.
And
That is not a
we-
problem. We
this
could have
court-
decided this matter today.
Because
This is pending since 2015. We could have decided this.
Yes,
matter.
Lordship, only that is who will pay, because later on what happened, initially they paid.
But his ground of adjournment is, I think it's a genuine. If it is, yes, Ms. Monto, why have you have taken a stand against them? You have served this copy yesterday.
He asked for me the copy, out of my mind, my mistake.
And
Yes.
problem is this,
Yes, my lord. I understand.
our all homework has gone in vain
Yes, Lordship.
for the whole day.
Yes, the order.
When, give a date.
Fix it.
Lordship, after 3 weeks, Lordship.
No,
No, not 3 weeks.
no, no.
Lordship,
no,
have to obtain.
no, no.
Next week. What objection? It's a question of law. Who will pay?
That is only the thing.
You only will have to give us the dates. On such date, this was state, on such date, this was, and we want only the dates. And you argue on law. For that you do not, Mr. Talukdar will not require an assistance from an officer.
Only that is, because in my case, some part has been paid by the government.
No, that part is his case, some
But
part
in
has
his
been
case,
already,
nothing is
but
written.
we are not paid.
Tell us, give a date.
After 2 weeks, Lordship.
No,
No,
date-
next week.
Let me, can it be fixed on 20th?
20th
August,
August, Lordship,
20 August.
we are giving, allowing him
Lordship,
some more
Lordship,
time.
That is about
And
complete
in this
time.
time, state government.
20 August, okay. Mr. Talukdar, learned standing counsel for
NHIDCL.
NHIDCL submits that an affidavit has been filed by the Revenue Department wherein a specific stand has been taken that in the event enhanced payment is required to be paid, it is the NHIDCL and not the state who is to pay such amount. Full stop. In the aforesaid backdrop, Talukdar submits that he will require some instruction from his client inasmuch as the copy has been served yesterday. A copy of such affidavit has been served upon him yesterday night only. Full stop. In the learned counsel for the petitioners has also not objected to such prayer, though they have expressed some urgency in this matter. Full stop. Accordingly, list this matter. List this matter.
It should be
20th
before.
August.
Huh?
20.
2008-2024. In the meantime, the NHIDCL may file affidavit in response to the affidavit filed by the Revenue Department. If so advised, however, same should be filed prior to the next date fix.
So they finally can dispose.
Lordship.
Okay.
In this matter,
Report.
Lordship, in this matter, Lordship, authority requested 2 weeks further time to complete the inquiry process, Lordship.
Okay.
They have sent a letter.
MSRB Bora, learned standing counsel, BTC. 6 for on instruction, 6 for 2 weeks further time to submit the report, submit the inquiry report as directed by this court under its order dated 11/6/2024. Full stop. Prayer is allowed. List this matter.
On 2nd of August, Lordship.
Huh?
No, can be taken up on 2nd of August. So,
2 weeks. He wants
1 week to.
not 2nd of August.
9.
After fifth week
No, Lordship,
starting from
after
5th,
5th. At least on 12th, Lordship.
12th of August. Yes, any development? Oh, where is the Mr.? Where is Mr.?
For him in the morning.
Okay, let us wait for some time. Where is PP? Augustin. মৌসুমী স্মিতা আহি পাইছে নেকি আহি পাইছে দেৰিকে অহা কথা আছিল হা এভিডেন্স খিনি লিখি থোৱা আছে Mr. Bora Goswami, I can ask him to leave for the time being. Let him do his work. Yes.
থাকিলে যাব কাম থাকিলে যাব
We'll record his argument while he'll argue. That will help us.
Yes. I will also give a short points if required within today or tomorrow. No, not very good point. 56 is the my lord FIR mail.
Just a minute. Page
Page 56 is the
Of?
FIR mail of the appeal memo.
appeal memo.
Not 57.
Just a minute.
Just to my lord refresh my lord. I'm reading the FIR.
Appeal memo. Yes. Yes.
Page 57 also.
Hmm.
Page 57. This
Page 57.
just to replace the facts, my lord.
Mm. Fifty
7 of the my lord.
appeal memo.
No, my lord, IA, sorry. My lord. IA 971/23.
57.
Yes. And Delay
Yes.
reference delay PSGD number 162 dated 8/5/2022. This is to inform you that on 8/5/22 at
Just a minute. Okay. Yes.
this is to inform you that that on 8/5/22 at about 10:30 PM an information had been received by me from reliable source that a large quantity of drugs, heroin is transporting from Dimapur to Assam through NH 37. Then immediately informed by the immediately informed to Deputy Superintendent of Police, Headquarter Depot, and General Diary entry was made by me by Delay PSGD number 162 dated 8/5. Accordingly, Inspector Mobik Brahma, OC Bukajan, self along with UB Raju Dwara, OC Kotkoti, Biplod Das of Bukajan PS, and Joyanta Bora, Ananda Rodnan, Sikaringti, Homnath Chetri, and so others, they are present. And accordingly, Naka was set up jointly on NH 36 at 12 mile nearby Delhi police station. I also informed to local Gabra and BDP member to present during Naka checking as a witness of the search, as the information was received after sunset at 10:30 p.m. So likely operation of entry, search, sunrise, seizure, arrest, etc. would probably be before sunrise. So a written authorization was issued to me by MS Nahid Karisma APS by Deputy Superintendent Police Karbi Anglong Difu, which is entered by Delay PS GD number 162 dated 8/5/22, who is empowered by Govt of Assam by notification number such and such manner. On the same day at about 11:15 p.m., one black color Ciaz car without registration number having chassis number such and such coming from Dimapur side was intercepted and checked in presence of local witnesses. Sri Zid Bahadur Chetri, son of such and such, address such and such, and second is Mohammad Abdul Ali, address is given, madam, and also MS Nahid Karisma APS Deputy Superintendent Headquarter Depot, who also turned up at PO on thorough search of the said car and the body of the driver along with the accompanying the car, complying the provisions of Section 165 CRPC and 50 NDPS Act, recovered 150 numbers of sub boxes of suspected heroin from the dicky of the said car, which is kept concealed in 2 numbers of rice bags in one black color polythene sealed with 3 color adhesive tape. Accordingly, driver named Langthang Stephen Tingho and another Malad village, Manipur, and other named Bhelpu Pro of village Kodom Kabi, such and such were apprehended. Apprehended persons were revealed during spot interaction that they carried the identical heroin from Manipur, which were procured from Myanmar. Further, they were involved in transportation, import into India, export from India, or psychotropic substances as disclosed by apprehended persons and as learned from reliable sources. International gangs are financing directly or indirectly to these kinds of illicit traffic drugs and psychotropic substance into India and from etc. Suspected heroin recovered from the said car was subject to field test and weighed with the polythene packet without container in respect of above named witnesses and Deputy Superintendent of Police, Headquarter Depot, and Inspector Mobik Brahma and OC Bukazan PS. The net quantity of is 1999.29 grams suspected heroin found after weight have been seized as per seizure memo following new process of law in presence of 2 independent witnesses above. I also seized the following items and others. Other seizure memo, there are total 8 items, along with a phone and bank checkbook. 2.8. I am skipping this, The next parent is suspected heroin packed and sealed at spot in presence of independent witness. After completing all these formalities, the police party departed from the PO at 1:45 AM on 9/5/22 to the Delay PS along with seized items with apprehended persons. It may be mentioned, being a sub-inspector, I am empowered by the notification such and such to carry out the search.
Yes.
So now, my lord, regarding the question of put, my lord, that the authorization letter so granted under section 42 is not exhibited. My reply to you be, my lord, that
Just a minute.
the authorized officer, my lord, who has given the authorization, my lord, he was personally present and my lord, and he was personally present and directing the authorization, my lord, at the spot, my lord. So my lord, my lord,
Do you want to say that, so therefore that exhibit is not
non-exhibit
is not fatal,
my
not
lord,
fatal.
because
Okay.
it is a part of the evidence of PW 3, who is the authorized officer, my lord.
PW 3.
Yes, my lord.
Okay.
Yes.
Just note it down. Non-exhibit of the authorization letter issued by PW 3 to the
Seizing officer.
seizing officer is not fatal in the given facts of the present case, as the person that the PW3 herself was present at the time of seizure. That is one. Okay.
Yes.
Yes,
that is
next.
Now, my lord, I am going to the teaser list, my lord, page 59, my lord.
Page 59 of this
Yes.
IA, na?
Yes.
Hmm.
Okay, my lord, page
59 is
60.
exhibit.
Yes, exhibit, my lord, it is exhibit P2 CW1.
Hmm.
Seizure list is exhibited, my lord.
Yes,
My lord, it will my page 61, my lord.
I'm at page 59.
Yes, yes.
Yes.
61 is the my lord type. 59 is the my lord type copy, my lord.
Okay, okay.
Yes,
Annexure P2, okay.
Yeah.
Okay. Yes, proceed.
Page 60, your lordship will find, my lord.
Hmm.
Number 7, my lord.
Hmm.
11 p.m. acting on a tip of intercepted a metallic pearl black CS car without number plate, and on being, my lord, that is important, my lord, black color CS car without number plate, my lord. That your lordship may kindly note, my lord. This is the specification of the car, my lord. But there is, because it is not numbered. On being thorough search, recovered 152 stock boxes containing approx 2 kg, 1.995 kg suspected identical heroin seized from joint possession of Lantapai, Stephen, Kinko, and Sri Baipur. During search, I have observed all the formalities. So, my lord, 2 kg heroin was recovered from the car, my lord. Now I am going to my lord, evidence part, my lord. PW1, my lord, seizure witnesses. Page 66.
Yes.
I know the complainant S.I. Lutfur Rahman. Today I have identified both the accused persons, namely Baipu Kru and Lanthamai Stephen, produced from the jail hazard through video conferencing. The occurrence took place on 9/5 at Delhi 12 mile after 11 p.m. On the day of occurrence, there was a police checking at Delhi 12 mile, and after 11 p.m. one black color car, my lord, that he has corroborated that it's a black color car, my lord, PW1, was coming from Dimapur side towards Delhi side without registration number. Police signaled to stop the car, and according the car stopped at Delhi 12 mile. The police personnel searched the car and recovered 152 numbers of sub boxes from the dicky of the car. My lord, may kindly note that it is a dicky from the dicky of the car, and which were concealed in 2 numbers of rice bags. That has also been corroborated, my lord. It is in 2 numbers of rice bags, right? Seizure witness number 1. There are 2 passengers, including driver in the car, whom today I have identified in the court through video conferencing. During the time of search, the officer in charge of Delhi police station, as SI, officer in charge of Bukazan police station, and deputy superintendent headquarter Dipu. My lord, that is the my authorized officer, my lord. He is also present. That has been, my lord, corroborated, my lord. Along with other police personnel were present at the place of occurrence. Police weighed the recovered suspected drugs in presence of me and found total about 2 kg. Police prepared a weight list in presence of witnesses, and I put my signature on the weighing list as a witness. Exhibit P1, P2 is the weighing list. Exhibit P1 are my signature. Later, police seized the recovered 150 numbers of soap cases, and each soap was suspected drugs were kept in small polythene packet whose total weight was about 2 kg, my lord. That has been corroborated.
Yes, yes.
Police have seen the documents from the possession. So, my lord, from to PW1, my lord, the seizure has, my lord, supported the seizure, my lord.
Mr. Goswami also contends the referring to the PW1 deposition of PW1, a seizure witness. Mr. Goswami argues that the deposition and assertion of the PW1 so far relating to recovery of the narcotics from the dicky of the vehicle and identity of the occupants as well as the vehicle has remained firm, and such evidence could not be shaken by the defense during their cross-examination.
Yes, my lord. In
Therefore,
cross, my lord.
Therefore, the factum of recovery of the contraband from the joint possession of these two accused person
Yes.
was established beyond any reasonable
Yes.
doubt.
And that's page 68, my lord.
Mm.
I have seen the seized 152 numbers of soft cases in the
According
court.
to Mr. Goswami, during the cross-examination,
Yes.
such recovery
Yes.
was reaffirmed by
Yes.
the PW.
In paragraph 2, my lord, he has specifically, my these are not in chief, my lord, this has come in cross, my lord, how he came to the spot, my lord, at that time. And this has been reaffirmed. And your lordship will
Further
find.
contends that having a good relation with police shall not cannot question the authenticity
No.
of such witness, in as much as it is also established that it is also established that he was a local, the PW, such seizure witness was a local man and a auto driver returning from Dimapur. Yes, next.
69, my lord, just one point I want to, my lord. A question was put to him regarding this, my confronted, my lord, regarding the seizure of the place of seizure of the contraband, my lord. Police did, so, my lord, he denied that police did not recover the soft cases
No,
from
that we have recorded. That
under the
we-
driver's seat or passenger seat. Well, that has been confirmed, my lord, because it is from the dicky, my lord, not under the
that
driver's
we have
seat.
said that
Lost.
come
That is-
from the confirm from
Yes,
the dicky of
confirm.
the vehicle.
Yes, that is.
Listen.
PW2, PW2 is also, my lord, I'm not reading, my lord, this is
No, not
also in a
necessary.
similar way, my lord, he has
From the
reaffirmed, my
PW1
lord,
and
what-
PW2 corridor. PW1 and PW2.
Yes, that I used to the VDP party from, and in cross also, my lord,
He further
He has-
contends that the statement of the
PW2.
PW2 during cross-examination that he is a regular witness to policies shall also not disclose his credibility in view of his firm stand during the chief and cross-examination.
So, my lord, one thing I want to, my lord, just cross part, my lord, page 71. My lord, I used to be at a PDP party from 9 PM to 12 midnight guarding the place. I have an identity card of PDP party issued by the officer in charge of Thana. I am one of the workers of the police department, as my identity card was issued by, till today police call me 4 times.
Further,
My lord, these are the facts, my lord.
Mr. Goswami also
Take that,
contends
my lord.
that the
Is-
petitioner, being a VDP, part of VDP party, in fact, works under the police department, and substance has been clarified during the
He is,
cross-examination.
my lord, telling that, I want to just stress that, my lord, he is telling the truth, my lord, that he is not hiding anything. And in the 72 page, my lord, your lordship will find, my lord, that the learned, my lord, petitioner, my lord, they have relied on that it is said that Abdul Ali was not present along with me at that point of time, my lord. As per his person, PW1 is not present. So, my lord, we cannot discard, we cannot rely on one part of evidence and discard the other, my lord. As a whole, if we take it, my lord, we have to believe that PW2 is also is supporting the case of the
Reading according to Mr. Goswami, reading the evidence as a whole creates no doubt about the credibility of this witness. Yes.
So, now, my lord, PW3, my lord. It is important, madam. The authorized officer who is present in the PO, madam. I know the complainant as I look for today. I have recognized the accused persons, namely such and such persons. The occurrence took place on 8/5, madam. As on 12 mile at 11:15, madam. Time is corroborated on the day of occurrence at about 10:30 PM. Officer in charge of Dilai Police Station SI Lutpurama informed me that a large quantity of drugs were transporting from Dimapur to Assam through NH 37. After receiving the information, madam, I directed the officer in charge of Dilai Police Lutpurama to set up a Naka checking. Then I proceeded to 12 Mile and reached the place. This has been corroborated that he was present at the place of occurrence at that time, madam. Next paragraph, madam, is the at some inspector and other persons who are present, my lord, he has corroborated. Next paragraph, at about 11:15, one black color Ciaz without registration number. LOC will find the same thing he has said. One black color without registration number corroborated SPW1, the seizure witnesses. Towards Manja side was signaled to stop at 12 mile. And accordingly, black color Ciaz car stopped at 12 miles. On thorough search, the state Ciaz car 152 numbers of plastic sub boxes from the dicky of the Ciaz car. That PW3 also said, man, the dicky of the Ciaz car, man, which were kept concealed in 2 numbers of rice bags, man. This is what the FIR also stated, and also PW1, 2 numbers of rice bags and the dicky of the Ciaz car. And one black color polythene seal packet with khaki color tapes and such and such. There are 2 persons in the Ciaz car. The name of the driver was such and such, and the name of the person, another person. Recovered suspected heroin were field tested at the place of occurrence, found positive to be heroin. Field test is important, that has been tested at that time. The recovered suspected heroin weight in presence of Inspector Movik Brahma, SI Lutpuroman at the place and occurrence found 199.25. This is corroborated with the other seizure witnesses. Later, the SI Lutpuraman officer in charge seized the recovered 150 number of packets suspected to be identical heroin, one black color Ciaz card without Ciaz registration, one Aadhaar card and other things. Next is the cross part. I was at around 10:30 PM. SI Lutpuraman called me and I reached the place at around 11 PM. I gave authorized letter to SI Lutpur Rahman to search and seize. This has come up from the evidence of PW3 regarding the authorization letter, madam, which is a part of the exhibits, madam, which is a part of the position of the PW3, madam. So we cannot, my lord, disbelieve, my lord, for any reason, my lord, that he has not given the authorization. And in the cross, my lord, if I'm reading the cross, entered inside the car. I did not enter inside the Ciaz car. There were 2 independent witnesses, the place of occurrence. I do not remember their names. And nothing was, nothing was recovered from below the driver's seat and passenger seat, my lord. It was recovered from the dicky of the car. And 152 packets, one by one, it was mentioned. The recovered heroin were packed and sealed in a cartoon at the place of occurrence, madam. Lossi may kindly see. It is argued that it was not packed and sealed in the place of occurrence, madam. Then PW3 is affirmation in cross, madam, last paragraph. The recovered heroin were packed and sealed in a cartoon at the place of occurrence after. That is important, madam. After signing of the independent witness, it is very important, madam. After signing of the independent witnesses, including me and other accused persons. So at this, my lord, there is nothing, he was not confronted with any question that regarding the authorization he has given, my lord, regarding the signature he has put in the seizure list and our seizure items, my lord. Nothing has been confronted, my lord. And so, my lord, at the seizure, and there is no question, my lord, that was confronted as witnesses were fraudulently taken or signatures were taken by my lord force or misrepresentation, signature of the accused person, my lord, in the contraband seized and also the seizure list, my lord. There is nothing in the cross, my lord. That is very important.
The statement of the PW tree that the box was the recovered heroin were packed and sealed in a cartoon at the place of occurrence, and same was and the independent witnesses as well as the PW3 put the signature is not being challenged by the defense, in as much as from the testimony of this witness also the recovery of the contraband was established beyond any reasonable doubt. Yes.
Yes, ma'am. Next is PW4, madam. As Seizure officer, madam. Page 78, madam. On 8/5/2022, I was posted at Delhi police station as officer in charge on that day at about.
He is the complainant.
He is the complainant.
Okay.
On that day, I received a secret information that a huge quantity of drugs were transporting from Dimapur to Assam through NH36. Then I immediately informed the matter to Deputy SP Difu, and I made a general diary entry by Delhi PS GD number 162 of dated 8/5 at 10:30 p.m. Exhibit P3, minor. This is exhibited, minor. Exhibit P3 PW4 is an extract of GD number, madam.
Where?
Page 79.
Page 79.
Exhibit P3 P4 is the extract of GD number 162 dated session 8/5. And exhibit P31 P4 is my signature, madam. That is the information reduced into writing, madam. I also informed the matter to Inspector Mobik Brahma, officer in charge of Bukazan Police Station, and Raju, officer in charge of Khatkati, and I immediately went towards 12-mile Naka checking with my staff. I also informed the matter to the local governor and BDP members and requested them to come to 12-mile. Inspector Mobik Brahma, officer in charge of Bukazan Police Station, Raju Dwara, officer in charge of Khatkati, and others who are present, the team, their names are there in his evidence. And also he specifically said 1, 2, 3, 4, 5, 6, 7, 8. On the 8th line, my lord, he has specifically stated that Deputy SP Difu Smiti Nahid Karisma, he is PW3, who is the person who is authorized, my lord, present, my lord. This is corroborated, my lord. Who gave the authorization was also present. Information was received as the information was received after sunset. So right, a person was entry, seizure, etc. would probably after. So a written authorization was issued to me by Nahid Karisma. He has also made it clear. The proof which was entered by the Delhi PhD number such and such. Here, just I want to regarding
Yes.
just one pausing for a moment, my lord, regarding the authorization, my lord, that has to be given by the my lord. I want to just make it some points clear, my lord, regarding section 42, my lord. Here, my lord, what happened, my lord, the admitted bid, my lord. After,
Just a minute.
Yes, my lord, single time is 42, my lord.
Yes.
Here, provided, I am
42. Power of entry search seizure.
Yes, power of entry search.
Which provision you want?
Yes, my this provision, my lord. Here, in a 41 also, my lord, it is stated that if your lordship may just before 41, 42, my lord,
Yes.
your lordship will find 41(2), last part, my lord, kept in 1 to last below, from below 4-5 lines, my lord. Liable for seizure, freezing, forfeiture of the is kept or concealed any building, conveyance or place, may authorize any officer subordinate to him but superior in the rank of sepoy or a constable to arrest such a person or search a building, conveyance or place, whether by day or by night, or himself arrest such a person or search a building. The officer to whom under subsection is addressed and the person who authorized the arrest or search or officer who is so authorized shall have all the powers of an officer acting under section 42. Madam. But 42, this is 41. So 42 is more specific that it is after sunset, my lord. Here, as per the proviso, my lord, after sunset, if, my lord, after sunset, my lord, if he has to make a seizure, my lord, and on the circumstances that he could not inform the my lord authorized person, my lord, then only the requirement is that he has to give reasons for search after sunset, my lord. This is very important, my lord. So that lordship may kindly note, because a argument has come from the side that no, my lord, nothing has been, my lord, made, my lord, reasons, no reasons have been recorded while after sunset it is, my lord, search has been made, my lord. So my reply will be that, my lord, this is a case where, my lord, the intimation was
Let us read 42 once again.
yes, my lord.
From one power of anticipation.
Power of any such officer of the Department of Central Excise, Narcotic Customs, Revenue, Intelligence, or any other department of central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order by central government, or any such officer being the superior in rank of a peon, sepoy, constable of the Revenue, Drugs Control, Exercise, Police, or any department of the state government, as is empowered in this behalf by general or special order of the state government, if he has reason to believe from personal knowledge or information given by any person and take down in writing, this is been done, my lord. He got the information, it was GD entry was made in any narcotic, drug, or psychotic substance or control in respect of which an offense punishable under this act has been committed, or any document or other article which may further furnish evidence of the commission of such offense or illegally acquired property, or any other document or other article which may furnish evidence of holding any illegal acquired property which is liable for seizure, freezing, or forfeiture under chapter 5A of this act is kept or concealed in any building, convenience, or enclosed, may between sunrise and sunset, my lord.
So this is sunrise and sunset.
This is sunrise and sunset, my lord. And these are the seizure part, my lord. And
Now provided.
they provided that in
Here
respect
it
of a
is
holder
after sunset.
after sunset.
Admittedly.
Yes.
Yes.
And provided that it a holder of a license for manufacture of a manufactured drugs, and this I am skipping, man. This is not really.
Provided that.
Second
provision.
provision, provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility of the escape of an offender, he may enter and search such building, conveyance, and enclosure at any time between sunset and sunrise after recording the grounds of his belief. That is, matter if he has to enter after sunset, first. Secondly, if he could not give intimation to the superior, two ingredients are there, my lord.
So according to you, when the
Yes.
superior himself is present.
No, my lord. Yes, superior is intimated earlier, my lord. So before, my lord, entering the sunset.
So your case is that the GD entry reflects that superior was intimated.
Intimated, my lord. So
Intimated, and therefore superior was
present
present in the seizure.
Yeah.
And therefore the proviso is not applicable in the given facts of the present case.
Yes.
This is your case?
Yes, my because my lord, if he has to record the writing, my lord, that is if he could not intimate, my lord, then only he have to give his reasons.
For relating to just I will phrase it out. You will
Yes,
give
yes.
a writing so
Yes.
that I can
Yes.
remember. during the it is also contended by Mr. Goswami that there is no contravention on the part of no contravention of section 42 of the act as urged by learned senior counsel for the
No
petition.
violation, my lord.
First of
Yes,
According to Mr. Goswami, when the officer, authorizing officer,
Yeah.
herself
yes,
was present at the place of occurrence,
who authorized him to, Yes.
place of the occurrence, non-exhibit of the authorization, authorization is not even necessary. Is it?
No, 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 authorization, my lord, is necessary, my lord, but my lord, recording of the reasons
Or full stop.
is not fatal, my lord.
Full stop. So you want to say
Yes,
that
I am reading the proviso once more, my lord.
yes,
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained, my lord, without affording opportunity for concealment of evidence or facility for escape of an offender. So if he may enter and search such building and convenience at any time after recording the grounds of his belief.
okay. Now we'll rephrase it like this.
Yes.
According to Mr. Goswami, though the written authorization letter was not exhibited, this is your case, same would not be fatal in the given phase of the present case,
Yes.
more particularly for the reason that the factum of authorization given by the PW3
Yes.
was itself recorded and such ZD entry was exhibited, and the said officer
Yes.
PW3 was herself present at the time of search and seizure.
Yes.
This is
This is the, and regarding the fact that, my lord, is a very important, my lord, the reasons has to be recorded while search and seizure after sunset, my lord. When authorization cannot be, my lord, taken, my lord. So my now, my lord, since as per my learned senior friend, my lord, no reasons has been recorded after sunset, my lord. So he has already given the intimation to the superior, my lord. So that part absolves him from.
His further contest that as the officer informant, is not it? As the
Yes.
informant
Yes.
already intimated his superior regarding regarding the operation that regarding the search operation which shall take place after sunset. Specific recording of non-intimation will
Specific-
not be fatal.
Specific recording of reasons for search in the after sunset
Specific reasons for search after sunset
will not be fatal.
not be fatal, more particularly for the reason that the said superior officer is part of the entire search operation.
Yes. Even though, my lord, contrary, my lord, I am submitting that in the ZD entry, it is there that a narcotics deal has been taken place, has to be taken place at the.
In as much as
my
the such fact was recorded in the ZD entry
No.
itself that there shall be likelihood of an search operation after sunset.
yes, sunset and
Hmm.
seizure in the after sunset.
Seizure in the after sunset.
That has been the ZD entry.
Yes.
That is something what
Yes.
I am clear. So, my lord, now PW4, my lord, I am just reading it out. The 79, my lord. Page 79. Exhibit P3, P4 is a extract of GD&T. Exhibit, I have read this, my lord. 79, I have read, my lord. 80, my lord.
Page 80.
80. On the same day at our 11 p.m., one black color Cia car without registration. That is again corroborated. coming from Dimapur side towards Delhi side was intercepted in presence of local witness, namely such and such. During the thorough search of the car and body of the driver along with accompanied in the car under provision of section 135(50) in presence of Smithy, Nahid Karisma, DFU recovered 152 numbers of soap boxes containing suspected heroin wrapped with a small polythene packet in each soap box from the dicky of the car. Here also, my lord. Dicky of the car, which was kept concealing 2 numbers of rice bags. Dicky of the car, my lord, 2 numbers of rice bags, all are same, my lord, my lord, corroborated regarding the seizure witnesses, PW3, PW4, and everyone, my lord. And there are 2 persons inside the car on asking the driver, such and such, and my lord, and this on spot interrogation. These are the other faces come up. This is not very relevant, my lord. Page 81. That page 81, recovered suspected heroin was field test by Smithy Nahid Karisma, APS. That is corroborated, my lord, from PW3, my lord. First, it was field tested and it was found to be heroin, my lord. The recovered suspected heroin weight in presence of Smithy Nahid Karisma and found net such and such. Then I seized 1 black color CS car, and this the seizure part also corroborated with other seizure witnesses, PW 1, 2, 3, my lord.
Yes.
Page 81, I have read, my lord.
He
Now,
is the
my-
IO.
he is the he is the my lord, seizure officer, not the IO, complainant, my lord.
He is a seizure officer.
Seizure,
no?
seizure,
Okay.
my lord, officer, my lord.
Oh.
Now, my lord, this is important, my lord.
PW4 is a seizing officer, isn't it?
Yes, seizing officer. Last, page 81, last pages, my lord. Having seen numbers.
Yes, Mr. Mozumdar. Instead of waiting, what happened to that review? Nobody was there.
Review now, they have withdrawn the entire court of inquiry, having just given a copy.
So Maternal is
So,
there.
my lord, yes, I was just waiting to give a copy. My friend was there in court number 1.
Okay.
So that could be closed once she comes, my lord, if she records my attendance, because she has to place it on the tape.
Okay. No
I'll
problem.
just give a copy.
You give the copy, let her be here. Where else have you intimated her? Maternal. Your purpose is served. Yes.
No, my lord.
Hmm.
Page 81, last 2 lines, my lord. Having seen numbers such and such in presence of independent witnesses and seizure was made, my lord, and Smithy Nahid Karisma, ASP DFU, and prepared a seizure list. Accused persons, and this is important, my lord.
Which, where?
Page 82, my lord.
82, okay.
The accused persons put their signature on the seizure list,
Hmm.
along with the independent witnesses and gazetted officer present, Nahid Karisma.
Hmm.
This is a part of, this is a very vital, my lord.
Hmm.
On the day of seizure, my lord, after seizure, my lord,
Hmm.
the seizing accused persons put their signature.
Hmm.
This will come from the evidence also, my lord. I will show, my lord. Accused person put their signatures. And the Nahid Karisma, my lord, PW3 also put their signatures, my lord. And the informant also put their signature, my lord. And this is corroborated with PW3 and 1, my lord. Because, my lord, PW3 has stated this, and other witnesses, seizure witnesses also stated, my lord. And in cross part also, there is nothing to say that what I have stated earlier, my lord.
Hmm.
In the cross part also, there is nothing, my lord, no confrontation has been made that whether if the signatures that were obtained in the seizure list and also in the, my lord, seizing items were with force or misrepresentation, nothing of that, my lord, questions are put to the accused persons and others, my lord. So now, my accused person cannot say, and defense cannot say that the signatures were not present at the seizure, my lord.
Now just tell us
Yes.
that it page 83, he
80
because of stress
eight-
was given on this
82,
Oh.
83,
83.
which part, my lord?
That is photocopy of the seizure list and the ZD date was mentioned, but the seizure list was not exhibited in the court.
See that because seizure list, the ZD date was mentioned, but this seizure was not exhibited
Hmm.
from the, was not exhibited
Hmm.
in the court. It is from for the cross part is there.
Okay, that is what just
Yes, yeah.
because much stress has been given that
Yes.
how it was kept, how it was sent for.
Yes,
They have not given much stress on the recovery part.
but this is,
Recovery is, suppose their whole case is that recovery is established. Even
Yes.
if it is assumed that recovery is established.
Yes.
But whether that recovered, alleged recovery made and the report of the forensic is of the same. That
Yes,
is their, that is their
that is the,
doubting.
I will explain also.
Okay.
Let-
That is their basic case.
This is basis case.
So
The-
far
the-
regarding recovery and possession, I do not think you have given much stress on that.
Yes, that, and my lord, that is the main part, my lord.
Huh.
The sampling,
They are they are basically harping on the violation of 42,
42.
that authorization non-exhibit. Second part is that how it was seized, how sample was taken, how it was sent to the
Yes,
expert, then how it was proved in the during trial that this is the sample
Yes.
which was recovered, this is the
Yes.
part of the sample. This is
Yes,
your case.
Yes, yes.
That apart, one thing is that during the custody, in 8 night,
Hmm.
8 May night, it was seized admittedly.
Hmm.
And how on the date for the entire day of night,
Hmm.
how it was kept,
Hmm.
whether it was in a safe custody.
Because
That is
that is what I'm saying, that it was suppose from the seizure to sending it to the forensic
yes, that part.
or to the magistrate before whom, that how it was kept.
Without
And
tampering.
there was that defense was raised during the cross examination. Yes.
Your lordship will see the, this is what I just want to verify, my lord. Exhibit P2, P1 is the seizure list, my lord.
P2, P1.
Yes, the seizure list, my lord. Here it is photocopy of seizure list, the ZD was, seizure list was not exhibited. This might not be, my lord, correct, my lord.
According to seizure list was exhibited.
Seizure list exhibited, your lordship will
Just
find from,
flag mark the seizure list in the.
from the judgment, your lordship will find, my lord.
No, we'll not go to the judgment.
Yes.
The moment we go to the judgment, we'll
Yes.
take a view.
Yes, my
It's a,
no, man, the list of exhibit.
no. You'll have to flag mark
Yes,
the
I'll
record.
flag mark.
Record.
I'll flag mark. It is
That it was exhibited.
P2 W1. Your lordship may record. I will just flag mark after that. P2 W1 seizure list.
Yes.
Now, madam, my signature. Seizure. The seized articles here, cross part, my lord has read it, my lord. That so I am skipping this, my lord. The fourth paragraph, I am reading 83, my lord.
Hmm.
The seized articles were kept in the Malkhana of the police station, but I did not submit any receipt with the FIR showing that the seized articles were kept in Malkhana. Only thing, my lord, he stated that it was kept in the Malkhana, that is specific.
Okay.
But he was in the cross part, my lord. There is no confrontation, my lord. It was, your lordship will find from the cross part, my lord, because here it is important, my lord. And nothing was specifically, my lord, intercepted, my lord, regarding the, my lord, keeping of the contraband in the Malkhana or not, my lord. Your lordship will see in the cross part, he stated kept in the my lord, Malkhana, my lord. But after that, your lordship may kindly see page 84, my lord. There is nothing in this, my lord, absolutely nothing, my lord, confronting that it was not kept in the Malkhana. Your lordship will see, my lord. I did not record the statement of such and such. These are not important, my lord. Next, according to the, it is not a fact that I take the exhibit P6, P4 photographs of the seized car at date. I did not take photograph of the decay of the car. I recorded the statements of
Okay,
local witnesses and computer, and I did not investigate about it. Computer is a why my lord. Here in chief part, my lord, he has also stated that he has taken the videography and he has seized the videography CD from HD Shankar Setri, my lord, in the seizure part. What I want to say, my lord, the seizure is
Hmm.
absolutely proof from these facts, my lord. That is what I. And here also, my one thing it has come up from my lord,
Hmm.
that today I have seen the videography CD in the court. Material object MO1 is the videography, my lord. This has come up, my lord, that the sub box are also marked as MO1 and the videography CD that has been exhibited. Both are exhibited, my lord. And now it is before the court, my lord. Probably there are some mistake in the numbering, my lord. But because material object M1 is the videography, is the MO1. And also, my lord, your lordship will find the material object also, my lord, that it is not confronted that
what is the date of seizure?
8/5.
8/5.
Your lordship will find, my lord, that no any question was put to him regarding the numbering of the same number in the two exhibits, my lord. Your lordship will find from the cross part, my lord. MO1 is the MO1. No any question was put to him that MO1 cannot be, my lord, video say it is a sub boxes. There's nothing, my lord. You have accepted that, my lord. That point of time. The process is very important at this stage of appeal.
Yes.
And page 85, my lord. And it is not a fact that I did not take the videography of the incident. It is not a fact that later on videography was made. He has denied the suggestion put to him, man. And no drugs were, it is very important, man. No drugs was recovered from below the driver's seat and passenger seat. He also made it clear, man. It is.
Yes.
There it has come up from.
Yes.
Yes, ma'am. Now PW5 is the matter. PW5 is the forensics matter. Here is the most important matter regarding there are the allegations that sample that has been drawn. First, it has been stated that as per section 52A2, no certificate, no application was made before the magistrate, as per their version, no application was made before the magistrate for drawing up the samples, This is absolutely not correct, On the same day, and the 9th, application was made before the JMFC first class, On that day, the seized contraband was put before the court, and after that, he has, after that, as part of order of the court, and he was asked to submit those contraband on the 10th, Accordingly, on the 10th, the sample was drawn, So, I want to, for that, I want to just, the file A, there is an order of the
You see, you
magistrate.
go to it, give the LCR to him.
Before that, just I want to just coming to the law appointment 52A2,
Yes, 52A2. Ah,
It is very legal. Center May 52 52A2 directly.
52.
52A2. This is the sampling part.
Yes.
Where any narcotic, drugs, psychotropic substances, controlled substance or convenience has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substance, controlled substance or convenience containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, and identifier of the narcotic drugs, psychotropic substances, controlled substance, or convenience, or the packing in which are packed, country of origin, other particulars of section may consider relevant to the identity. This is all because for the identity of the, to identify the contraband seized, my lord. Identity of the narcotic drugs and substances, and this is important, and make an application to any magistrate for the purpose of
Just may consider relevant to the purpose of so and so.
Yes.
And make.
make an application, that is important. Make an application to any magistrate for the purpose of certifying the correction of
Correctness of
the
inventory.
inventory so prepared, taking in the presence of such magistrates photographs of such drugs, substances, conveyances, and certifying such photographs as true, allowing to draw,
They are basically on C.
allowing to draw, no, but they are also saying that no applications
Okay,
were made.
okay, okay.
Allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certify the correction of any list so drawn. Where an application is made under subsection 2, the magistrate shall as soon as may be allow the application. Now, my lord, notwithstanding, 4 is important, my lord. Notwithstanding anything contained in the Indian Evidence Act 1872 or the Code of Criminal Procedure 1973, every court trying an offense under this act shall treat the inventory, the photographs of every court trying the offense, my lord. This is on regarding, it is regarding every inventory. Shall, Roshi may kindly see, every court trying the offense under it shall treat the inventory, photographs of the drugs, psychotropic substance, controlled substance, or contains any list of sample under section 2, subsection 2, and certified by the magistrate as primary evidence. Already, because the order and certificate of correctness and everything reflect in the order. These are primary evidences, my lord. Primary evidence in respect of such offenses. my lord.
Primary evidence, it has been treated as primary evidence
Evidence.
because of the certification by a competent magistrate.
Competent, that is why, my lord.
That is why.
That is now,
Exhibited, man.
Provided
Provided it is exhibited.
my lord, now I am coming to, my lord, the because once it is a primary evidence, my lord, the court trying the offense can took into account, my lord.
No, understand.
Yes, that is
When it is primary evidence,
my lord.
that will become primary. What is their case is, this will become primary evidence, no doubt about it.
Yes.
But where is the certification?
A certification I am serving it, my lord.
That is it. They are saying that, okay, this is a law, but certificate, where is the certification? Where is the exhibit of the certification that this is the material, this has been certified? This is their case. Just
Yes. Impugn judgment. Personal, kindly come to 63 page, my lord.
page 63.
Yes.
Yes.
These, photographs. My lordship will see exhibit P25 PW6 is the certificate given by the magistrate.
Exhibit
P25
page by PW6.
6. Certificate given by magistrate under section 52(a)(3) of NDPS Act. So, my lord, may kindly see the last part. There is a certificate and also the last part, my lord.
Signature and
Page
designation.
63, my lord. Whereas the police officer, SI Lieutenant Amen, applied to me under subsection 2, section 52(a) to certify the above inventory and
I'm having satisfied the above
and
inventory.
having satisfied that the above inventory as per the seizure list and seized goods related to case when before me, certify the correctness of the above inventory with the signature of the my magistrate and certified given certificate given by the magistrate and certificate itself is exhibited as exhibit P25 P6 and
Who exhibit by PW6?
yes PW6. So you can now calling my lord the magistrate to certify the my lord signatures, my lord, it is not fatal, my lord, and it is not important in every cases, my lord.
That's not it.
Yes.
According to them, the author who has issued the
It
certificate
is not
was
executed, not examined.
not examined and signature was not proved.
Yes, because that he was not
Exhibit is proved.
Exhibit is
It is it is exhibited, no doubt, but content is not proved. This is the case.
that is their case, but my
So
case is
therefore,
that
just I will request you just that you have argued that when certificate is proved,
yes,
the specific proof of the signature of the magistrate
is
by the magistrate himself
calling-
or by the officer himself shall not be fatal,
yes, that is
more particularly when the other
certificate
things are established.
yes.
So it's just you put a note on that and
And at least
and give up.
today or today.
No issue, no issue. And
Only one thing, for his convenience,
Lords,
the magistrate has prepared the inventory as per him before the they have filed a petition and accordingly magistrate has prepared the inventory.
inventory was certified by magistrate.
Okay, inventory was certified by the magistrate.
magistrate.
So when the inventory is certified, it has to be produced before him. It has to be prepared before him. All the inventory, all the materials has to be prepared and accordingly then he will certify. Now, when it was produced before the magistrate.
so that will come because you have a specific point on that. The travel between the place of occurrence to the nearest police station to the magistrate.
No, there's one more point, my lord.
Yeah.
The inventory, as per the evidence of, it was seized on 8. Thereafter, application made on 9. So ultimately, it was produced before the magistrate on 10th.
No,
Right.
I will.
Okay, let him. I have noted your points. Take your seat. Just note down what. Just note down. Just note down his point. He's noting it down. Yes.
It may try. Right.
Okay. We're coming back. So, how much time will you take? 1 hour again?
Yes, I will have to take.
So first up, we'll
Yes. Subsection 3 of section 52A of Narcotic Drugs and Psychotropic Substance Act 1985 and hereby certify the correctness of enclosed inventory, enclosed photographs taken and list of samples drawn in my presence. Exhibited now. Now, I'm going to the orders, my lord. What happened on 8/5, my lord? 11 p.m. it was seized, my lord.
just a minute. 8/5/2022.
2, my lord.
11 p.m.
Yeah.
Says
11 p.m. my lord. So, my lord, generally what happened, 8/5, it was seized, again it was produced on 10/5. It looks like that, my lord, for one and more than 1 days, my lord, it was, a sample was in the, my lord, kept at the,
Everything was closed on 9/5
yes,
2022 at 1:30
yes, my lord.
AM.
Yes, my lord, because 8/5 to 10/5,
Ah.
this, it looks like, my lord, it is not,
Ah.
but my lord, what happened, 8/5, 11 PM. After that, my lord, after 12, my lord, it becomes 9, my lord, the date is 9. So, and the 9th, my lord, that is at the same day, I will say the same day, my lord, because 11, 9th morning, my lord, it was placed, I am reading from the order, my lord, this order has been, my lord, my lord, read over by my friend also, my lord, for,
Flag market.
yes,
Flag musu.
these two importance, 9/5,
Plastic flag.
yes, my lord.
Give this.
9/5 import, 9/5 order and 10/5 order, both are important. I'm moving on. I'm going directly to the, my lord. First is the bail part, my lord. Yes, my lord. Appearance part. Secondly, the prayer for drawing, my lord, on the 9/5 order, my lord. There is no, the same
We'll
day, I'll
see.
say the name. IO concerned. IO concerned also prayed for drawing representative samples, correctness of photographs of seized substances, seen and will be produced, seen and will be produced the substances tomorrow. That is 10/5, my lord. On the order of the learned JMFC, my lord,
Yes.
for it was for the samples are seen, my lord. And next date, my lord, that is on 10/5, my lord. Today, 10/5, I am also marking this
Mark.
order, my lord. Today is the date fixed for drawing samples. Accordingly, the IO is present along with the seized substances. The investigating officer of this case, SI Rafsansi Ahmed, has prayed for certifying the correctness of the inventory, take photographs of the inventory, drawing of representative samples of the seized substances in connection with instant case as required under section 52A of NDPS Act, and also prayed to pass order for pre-trial disposal of peruse the same, prayer is allowed. IO has produced following narcotics, drugs, controlled substance in seal condition. Seal with marking cloth. That has come from the PW, also stated that it was sealed and with a marking cloth and sealed. 152 numbers of plastic soap boxes different color contained in plastic, identical in shape and size, each package containing, my lord, suspected to be heroin. The seal of the seized substances is broken in my presence by Rafsanji Ahmed, and it contains 152 soap boxes which were marked 1 to 52. The soap boxes were opened in my presence and same contained 152 plastic pouches. The 152 packets containing the seized substances were weighed and photographed in my presence. The weights are, 152 weights are given, my lord. And after that, accordingly, I have tallied the articles produced before me with the inventory and in my presence prepared by SI Rafsanji Ahmed, and I hereby certify that the said inventory so prepared. Similarly, the photographs of the seized substances were taken in my presence, and I hereby certify that the said photographs are true photographs of the seized substances. The seized suspected contained in the 150 were made into 15 lots, lot 1, lot 2, lot 3, and to 15. Each lot is made into a homogeneous mixture from which 2 representative samples were drawn. And these are very important, my lord. Each lot is made in homogeneous mixture, and after that 2 samples were drawn, marked as lot 1, sample A, B, lot 2, sample A, B, lot 3, sample A, B. Out of that, sample A was forwarded for FSL, my lord. So there is a, my lord, allegation that the sample drawn before the magistrate is not sent to the FSL, my lord. That I will reply, my lord. So lot 15, sample A and B. It is to be mentioned that the empty plastic pouch containing sample weights about 0.45 to 0.65 grams. Plastic pouch, madam. It also weighs 0.45 to 0.65 grams. If your lordship tally the evidence sample A, my lord, the weight of the sample A and the weight, my lord, said by PW, my lord, 5, the scientific officer, my lord, that he found, my lord. So the difference is the regarding that plastic pouch, my lord. So it is the same sample, madam. That I will show from the record also, madam. So the samples were sealed. Again, madam, the samples were then sealed in my presence and photographs. And I hereby certify the correctness of the list of samples so drawn along with the photographs. After drawing the representative samples, the remaining seized substance are again sealed in my presence by the IO in the wax seal of OC Bukazan PS. That is the facsimile, my lord. Wax seal of OC Bukazan PS. That is intake in the samples, my lord. Because that will come, whether it is there or not, that will come from the evidence of scientific officer, my lord. So let the representative samples, the remnant seized substance is in sealed conditions be returned to the officer in charge for continuing with the investigation. Also let the photocopies of certified inventory and certified photographs be given to the IO as regard the prayer of the IO. This is for disposal part, my lord. I am not doing, right? Now, my lord. So lot A. It's coming 5.31. Lordships comes with my evidence of PW 5.
PW
5.
yes.
Page 87. Madam.
Yes.
For that, Lordship may kindly come to the FSL report, madam. FSL report, that is at page 65, madam.
65.
Yeah.
This was exhibited as
Yes. P9 PW5.
P9 PW5.
Your Lordship will find description of articles.
Articles.
Yes. Envelopes, numbers of seal envelope marked as lot 1, sample A to lot 15, sample having a closed polythene packet containing 5.31 gram. Your Lordship will find 5 here, my lord. The sample drawn is 5.65 gram, and the powdery substance was there 5.31 gram. Again, your Lordship will see in lot 2, sample A. 5.
He's comparing with the order of the magistrate.
Order, no, my lord. FSL that has been alleged, my lord, that the sample that was received by the
Weight does not tally.
weight does not tally.
With the
Yes.
Original my lord, sampling order, my lord.
Hmm.
That is what I am trying to explain, my lord,
Hmm.
why it is not telling, my lord.
That,
The 5.5, the second part, my lord, lot 2 sample A, 5 point,
Lot two.
that is lot 2, my lord. Your lordship may.
Now I'm at lot one sample A
Yes,
to lot 15 sample A, each having closed polythene packet containing 5.31 gram.
yes.
So and so on
Yes,
and so
so and so.
forth.
These are from lot A to lot 15, my lord,
Mm.
sample A. Before the my lord, magistrate, lot, my lord, along with polythene packet was weight, my lord. That I am not saying in vain, my lord.
Mm.
That has come up from the photographs that were taken at the time of weighing, my lord.
Mm.
That is exhibited, my lord.
Mm.
So along with the, my lord, polythene packet, it comes to 5.65 before the magistrate, my lord.
Mm.
And before the, my lord, FSL expert, my lord,
Mm.
that is 5.31. That is 0.4 gram
Minus
Point-
the plastic.
minus the packet, my lord.
Where is that packet? From where you are saying that it was, this is the weight of the packet?
From the photograph that has been
No, no.
exhibited, my lord.
From the, you are,
photograph on.
huh?
Yes,
Photograph. There's
um,
no weight has been
because
calculated of the
this
polythene
weight has
bag?
been calculated.
With
No,
and
my
without.
lord, no, that cannot be one. But what I am saying, so 5.31 has been calculated by the FSL expert, my lord.
Huh.
That has been exhibited, my lord.
Mm.
On one part, my lord,
So according to you, what we will understand, according to you, in
Yes.
terms of exhibit P9,
Yes.
the it contains so and 5.3 grams, so and so, so and so.
Yes.
Did and exhibit, which exhibit?
My lord,
That photograph exhibit?
photograph, your lordship will find there are 15 photographs, my lord. I am giving the photo page 36.
No, just tell us, these are
Page 30.
exhibits,
Exhibit P11,
P11.
P11 and afterwards, my lord.
So all these are
Yes,
photographs of the
P11.
sample taken.
Yes, P11, P6. Lordship may kindly note.
Just let me understand.
Yes.
So just I'm phrasing your argument.
Yes.
Here 5.31 gram or whatsoever grams are there.
Yes, because this is very specific.
Huh.
Question,
Huh.
my lord,
So,
allegation,
and
my lord.
in the exhibited photographs,
Yes,
it is clarified that plastic packets weight is such and
Yes,
such gram,
such and-
and if it is deducted,
it
then
comes
it
to,
is
my
in conformity. If both these exhibits are read together, then there is no
No
difference in the weight. This is your argument.
Yes,
Just phrase it and give
yes,
us.
yes. P11, PW6. Lordship may kindly just mark page 36 of file A in the record. And that is why I am saying so. Lordship may kindly see. After drawing the samples, after making sample A 5.6, sample B 5.82, the learned magistrate specifically stated it is to be mentioned that the empty plastic forms containing the samples weight 0.45 to 0.65. He has mentioned it, my lord, that the weight of the plastics, my lord. Now I am going just one.
But will it not require that magistrate to depose that factum, that this is a fact? It
No,
is
my lord,
reflected in the order.
That is why I am saying that it is already a primary evidence, my lord. Because the certificate.
No, what is, just clarify, because they have given a stress on it.
Yes.
You understand the issue.
Yes.
Issue is that to be an primary evidence, a certification is required.
Yes. That, yes.
Okay,
Yes.
certification is required.
Yeah.
This is one aspect.
Yeah.
Other aspect is that while how the certificate was issued,
Yeah.
that fact is recorded in the order, isn't it? So in the order, certain facts are recorded on the basis of which certificate is issued. Another part is the result is the certificate.
Yes.
And that certification gives a value to that evidence.
Yes.
That is a primary evidence.
Yes, that is the primary.
The very evidence. Now to accept this to be a primary evidence, the condition precedent is that this certification, who issued the according to them, who issued the certification must come and say that yes, these things I have done, whatever recorded in the orders, that officer will come and say that this I have done, and this is the certificate I have issued, this is my signature. According to you, this is not fatal. Just, that is not fatal. Why not fatal? You
Because-
just tell us and
Why not fatal, my lord? Because the same, because the certificate that has been issued, my lord, is exhibited, my lord. Exhibited.
so
and
that
it-
is their case. They
Yes.
said mere exhibiting is not a proof of the document itself.
Yes, because, and also,
There's a one more factor,
Yes.
that is he is missing, my lord. The certificate kindly see once, man.
Hmm.
Whether this is certificate and can be treated as a certificate. That's very important aspect, my lord.
Which
The
one?
certificate,
Hmm.
the exhibit, my lord,
Hmm.
inventory.
Ah.
What he is harping on,
Hmm.
that this is the P25 is the inventory.
You
made.
understand, you are coming to the serial number,
No.
152 numbers of
No,
Spencer
no.
Spencer.
I am just clearing to my learned senior friend, my lord.
This
The-
is exhibit,
This, another certificate is separately, there is a certificate.
where
that
is the one more certificate?
It is here,
Where?
Exhibited.
exhibited. it
Which
is.
one?
Which
Which one exhibited? Only one.
You are
one
saying,
exhibit.
you see, that's why you
Only page
page 63.
Page 25.
Right,
Yes.
W6.
That is Xerox copies annexed with the
No.
IA at page 63,
Yes,
isn't it?
yes, that is the only inventory.
No, no, man.
Is there
It
any
is
other
there.
inventory?
It is there. It is
Which
there.
one? Exhibit?
Which one? It
Which
is
one?
there.
Where is the exhibit?
It is there.
No,
Which one?
tell
Tell
us
me
the
the-
exhibit.
Tell me
It
the
is
exhibit. Tell us the
P25
exhibit.
PW6.
Huh?
That is the
That
inventory.
is the-
But why I will say false thing.
Yes, yes, yes. Let us.
I am saying for a record, my lord.
Yes,
I
no,
think
that's
for
why
any-
we'll
Which
go.
number? Judgment of account?
We'll
Judgment
say,
of money logic can see.
we'll see the record only, not,
is
but
page
not the
40.
Xerox copies.
No, my lord, it is.
One logic.
Do you want to say that this exhibit is?
Just in loss mercy.
The appendix of the judgment,
Hmm.
page 48.
Where is it?
That is very specific, my lord.
Which exhibit? Full year to the second.
This is Mr.
P25 hang on to that.
No,
P25.
Mr. Bora, just go through it. Inventory page 63
Yes.
is
It is-
not separately exhibited.
It is along with the order,
We do not know. It is along with.
along with.
There is a separate certificate along with page 3. That is the magistrate session judge has signed and exhibited as P25 by PW6.
Exhibit P25, my lord.
Page P25. That inventory page 43, page 63.
Yes.
Page 63 is a part of the certificate. What it says is, I allow the above application under section subsection 3 of so and and hereby certify the correctness of the enclosed inventory, the enclosed photography taken and the list of samples drawn in my presence. It's a separate exhibit, just go through it. And thereafter that an inventory is the table and all.
Because judgment, we are going by the judgment. It
But
does not say about that exhibit.
understand. This was also not the, this is the exhibit.
This
which
is a
read.
PWP, but this is, but in the list of exhibit, it is shown, my lord.
Okay.
Yeah, there must be two exhibits because we have only one exhibit, my lord.
No, that exhibit you are saying page 63
Yes.
is along with this, though it is along with this.
Logic, can I see one thing, man?
You go through it.
PW6 only, we can go by the evidence of PW6, man.
And before that, just, no, no. I just stopping in the middle.
Huh.
But what I am saying, my lord, from the records, I have nothing to hide, my lord, the lawsuit.
That certificate, that first page. PW6, where is the PW6's evidence? Let us see.
Page number 91, relevant portions. Page 91. Exhibit P25, the certificate given.
Your lordship, page 91, paragraph.
Second paragraph.
Second paragraph, your last portion, your lordship will find. P25, PW6. is the certificate given by the magistrate. So, my lord,
So, my
the
lord,
contention that there
only
is
concern
no,
is now,
Huh?
there are two exhibits
Uh,
under P25. Exhibit number P25, है ना, अब हमारा.
It's just marked in the record, flag mark it in the record.
So,
Hmm.
if
Hmm.
that means if he is correct, my lord,
Hmm.
so there is two exhibit
Hmm.
under the same number
Hmm.
P25.
That is, other part is that your page 63.
but it is
One
not.
part is page 63,
Uh,
one part is.
Yes, yes.
first page.
Inventory code mark.
एक मिनट,
एक बार तो लिखा है ना?
This is not,
It is not marked. It is not marked.
no mark.
No,
It is
no,
not
no.
marked.
This is
Only the certificate is marked, madam.
Huh?
We have a certified copy, my lord.
Just go
Statement-
through, find out the certified copy from the record.
Yes.
You have a certified, original must be in the record.
Yes.
Just go through it.
Page 63.
Page 63 is annexed with that page, certification.
Here in the page 63, your lordship will find there is no marking of
No,
the
no, ma'am.
certified
That I've
copy
seen.
also. The certified copy.
They are confused because of their certified copy.
Yes, certified copy, but not the exhibit.
No. The certified copy given to them. So
Yes,
that
yes.
is why I'm asking
No,
that
madam,
if they,
that is the
any
con-
copy of that certificate is there.
In the certified copy, that has been, there is no mark of exhibit.
Mm.
If your lordship see the page.
That page 43 is there is no mark of certificate.
63, there is
Page
no,
60 no mark.
because it is along with the certificate. The certificate, now, madam, we can, since it's a evidence, madam, we can treat it as a primary evidence. As per the section 52A clause 4. Now, হয়েছে এটা?
Yes, you proceed.
I have exactly.
Let us do one thing. Let us come back at 2. Go
Ma'am.
through. Mr. Bora, both go through. You have gone through. Okay.
Just the sampling part I am making it clear because we are in the middle. Now the certificate that has been given, my lord, that is, I have relied on, it. I have made it clear before your lordship that it is the order which has come on the 9-5 order and 10-5 order it has come, my lord. And this is, and from this has been authenticated by the certificate and that is exhibited, my lord. So it is not.
That's the point noted.
That is, that is the primary evidence now. So it need not be again proved before the court, my lord. Because once it is, my lord, trial court, that is very specifically that the court trying an offense, this is the language of the statute, my lord. So when the court trying an offense, there cannot be, my lord, again, it has not to be proved, my lord. Now your lordship will see regarding the weight, my lord. Why I am saying so?
Okay.
Now wait. Lordship may kindly mark P11 page, P11 PW6. That is, my lord. Yes. I'll mark one, my lord.
Just flag mark, very important.
Blue flag. The photographs, my lord. Now your lordship will find Okay. So it will exhibit. Another diagram I'm not finding it now. I will find it, madam.
What is that?
Regarding the weight with the polythene, madam. Why it is discrepancy of 0.4 and 0.6.
Okay.
That,
You also mark that.
yes, that I will find it, madam, because there is a photograph of it. Specific photographs. And your lordship will find, madam, I have flag mark 1. The seal, my lord, seal contravened, madam. Before it was opened before the magistrate, it was signed by 2 witnesses, signature of 2 accused, PW3, and also the seizing officer, madam. It's very specific one. And thereafter, then your lordship will find that the seal was broken before the magistrate, madam. So seal at the time of seizure and before it is produced, before the magistrate, my lord, it was in exactly sealed condition, and that the order also reflect, and also the photographs that is exhibited that also reflects, my lord. May kindly go through the order dated 9 and 10. The things will come in at 2, my lord.
At 2. Okay.
Let's try to do will you proceed?
No, I have no problem. I thought you will want to go through
Yes,
this record, that's why.
Yes, I have gone through, my lord, what I
You
have,
can continue, no
yes,
problem.
that the discrepancy I have
Uh-huh.
made out.
Yes.
So, my lord, lordship may kindly come to. I am not finding it that, my lord, the market
Yes.
regarding 5.85,
Yes, yes.
that I'll mark it now.
Now PW6.
Yes, my PW6, my lord.
This is the IO.
Yes, PW5, my lord. I just
Okay.
want to make it clear, my lord.
Hmm.
Forensics, because it's very important, because there the weight of the is certain, my lord, questions have been raised, but this is not the actual contraband, because the contraband itself is my lord, negated by the learned appellant, my lord, on the appellant side, my lord, that it is not the contraband that was seized and produced before the FSL, my lord. So, my lord, to bringing on the link, my lord, I have shown the magistrate's order, magistrate's certificate, and thereafter, my lord, after magistrate, my lord, it was sent to FSL. That I am just coming to the evidence of the FSL, how it has been reached to FSL, my lord. So, lordship may kindly come to page 86, my lord. On 13/5/2022, I was working as scientific officer, drugs and narcotic division, director of forensics. On that day, I received a parcel from my director of forensics science, Assam Kali, in connection with DLI PS licenses under section 21C for examination. The parcel consisted of 15 exhibits that has been drawn before the magistrate, my lord, enclosed in a seal envelope cover. The facsimile of the seal was found to be OC Bukazan PS, if I lost it, page 87, my lord. And this, my lord, seal has been, my lord, this seal was made before the sampling and before the magistrate, my lord. And before him, my lord, the seal was made, and it contains, my lord, OC Bukazan PS, my lord. This Bukazan, it also now, my lord, after in seal condition, the sample, I want to stress is that seal is intact, that means sample is intact in the same. And after my, the envelope cover is just OC Bukazan PS. That is corroborates, my lord. Now, my lord, description of the articles, 15 number of samples, lot A, sample A, lot 15 sample having a closed polythene packet containing 5.31 gram, 5.52, 5.51. In all, if your lordship takes the 15 sample as a whole, my lord, your lordship will find just 0.4, 0.3, 0.5, this some
Weight of the
weight of
plastic.
the plastics, my lord. And I have tallied with the by calculating, my lord, I have tallied that, my lord. This is actually exacted a polythene packet, my lord. Yes, ma'am. Among substances marked there as accordingly. I have examined the sample mentioned above as per United Nations Drug Testing Laboratory manner. I informed the report as such and such. Result of the examination is the exhibits D1 to such and such gave positive test for heroin, and the percentage of heroin in his exhibit was found to be 87.52. I signed on my report on 12/7 and forwarded to SDPO Bukazan. Exhibit P9. This is P9, P5 is my report. Exhibit P9, P5 is my signature. Page 87 last section. Exhibit P10, P5 is the forwarding address to subdivision officer Bukazan and was forwarded. And exhibit P10. Exhibit P10, PW5 is the signature of Dr. Tiloka Das, which I know. Now, we may come to cross part. Now, where is the challenge to the FSL report, madam? They have accepted, madam. Nothing your lordship will find, because under section 37 of Evidence Act, my lord, any question has been put that the FSL at that time also there is a difference in the, my lord. Everything is before them, my lord. The weight of the sample is before them. Everything is before them. What question they have put? What question they have put, my lord? That it is not the same sample. They have accepted. There is no challenge to the FSL, my lord. Report, my lord. And then nothing that the seal is broken. Nothing that the seal is, because he stated, my lord, in the FSL, my lord, in his deposition, my lord, he stated that FSL is intact with OC Bukazan case, and nothing has been stated. And your lordship will first see the cross one, how the cross is done. I have not mentioned in my report the date of examination. I concluded examination on such and such. Nothing, any question, my lord, regarding the authenticity of the FSL report, my lord, and authenticity of the samples present before him, my lord. So, my lord, from the evidence of PW5, my lord, now first seizure, now I have gone to the sampling, and I have gone to the, my lord, report of the FSL expert, my lord. From the chain of events, my lord, it is now, my lord, coming to crystal clear that the contraband that was seized is produced before magistrate, and after that it was produced, sent to FSL, and accordingly report has come, my lord. That is heroin, my lord. That is PW5, my lord. Now PW6, my lord. I know the complainant SI Lutfur Rahman. I have PW6 I have dealt with, my lord.
You dealt with it.
PW6.
Who is PW6? That is
Yeah, PW6, I have not, man. It is the
IO.
IO, man. I have not read it.
Not-
Man.
You have dealt with that seizing officer.
Staging. Shall I read?
Huh.
May I read? I know the complainant SI Lutfur Rahman on 9/5. I was posted at Bukazan as attest officer on that day. SI Lutfur Rahman filed an Azehar before Dilai Police Station Inspector Mobik Brahma received and registered the Azehar by Dilai Police Station and directed me to take up the investigation. On the same day, as per direction of SDPO Bukazan, Inspector handed over me, Mobik Brahma handed over to me all the materials along with the accused person's name. Then I examine the complainant, SI and recorded. These are the facts, my lord. And my lord, here was the occurrence, my lord, third paragraph, my lord. Occurrence took place on 8/5. It is corroborated, and at that time, LOC will find, my, it is very important, my lord. The occurrence took place on 8/5, and at that time, HG Shankar Shetty made a videography of the incident. Hence, I seized the CD and took certificate under section 65B from me. Material object MO is a seized videography CD. Regarding the marking of that, my lord, the lordship will find there is no question that since it is marked as same number, my lord. Yes, a proceeding is going before the, my lord, magistrate, my lord. What has been shown to him, my lord? He will not say that, my lord, a softbox to be a video CD, my lord. That will be very absurd, my lord. It is a seized video CD. Today I have seen the videography CD in the court. Before the session judge, also before the session judge who also seen it, and it is also seen before the session judge also, my lord. On the same day, I produced both the accused person and the seized articles before the CMFC Buka. Then I submitted a prayer before the will allow the accused persons. The lordship will find it. I'm just forgot to point out, my lord, page 90, my lord.
Yes.
On the page 90, on the same day, that is on 9/5, the lordship will find. In page 90, last two lines.
Page 90.
90, my lord.
On the same date.
On the
Third
same day,
paragraph.
on the 9/5, my lord. And the lordship has found the order dated 9/5, my lord. And this is corroborated by his own evidence also. I produced both the accused along with the seized articles before the court of JMFC Bukazan. Therefore, I submitted a prayer before the honorable court to allow both the accused persons for 10 days police custody. But the honorable court allowed 4 days police custody. I again on 10/5, your lordship will see, man. On 10/5, because he was ordered to submit in the next day as per the order, man. Because that is why on 9/5 we taken, and 10/5 I again brought the seized article before the JMFC, and I weighed and marked the reference sample, and I made total these are all the samples and exhibits. PW11, PW12, PW13, 14. These are all the photographs and exhibits. Exhibit P24, and last your lordship will find exhibit P24, P6 are the photographs of weighing and marking of representative samples before the learned JMFC Bukazan. P25, P6 is the certificate given by magistrate under 52A3. And I returned Bukazan along with the seized articles. After that, my lord, he returned to the Bukazan. Then I again interrogated both the accused one, but they had stated some statement as earlier, which I recorded on 9/5. On 11/5, I, along with the officer in charge of Bukazan police station and the staff, went to Senapati district of Manipur with the accused Bhaipe and appeared before as the accused confessed before us that he had brought the heroin from Senapati district of Manipur. There we met with the officer in charge of Senapati police station, but the officer in charge Senapati had resisted as there would be some problem of law and order as the villagers of the accused are agitated by the work of accused persons. Then we returned back to Bukazan along with the accused pro. On 12/5, I again interrogated both the accused person, but they stated the same as earlier, which was on 10/5. Hence, I had not recorded the statement. On the same day, I sent the forensic samples to on 11. They went to Manipur only one day, and after drawing samples, and on 12 they again sent it. So there is no that it is an inordinate delay, my lord. Even the delay of 48 days also taken into account, my lord. I forwarded both the accused persons to be honorable for on 22/7. I received the forensics laboratory report. I perused I submitted search sheet. Videographer. On the day I was present in the spot, the name of videographer was not mentioned in the cross part. Complaint recorded the statement of witness, namely, I have recorded statement both the accused person, but I have not seen the signatures. But I have not mentioned any. Delay not mentioned. Delay not mentioned. On I drew the samples. First, may come to the cross parts. I'm just going on. On 10/5, I drew the sample of the heroin before and kept the samples at. Now, you may kindly see there. On 10/5, I drew the sample of heroin before them and kept the sample Bukazan Police Station, Malkhana. I have not maintained register. I have not recorded the statement in the same Malkhana. Out of 30 samples, I have sent 15 samples. মই পঢ়ি দিছো এখানে আপনার কিন্তু পঢ়ি দিছো out of 15 samples were kept in Malkhana of Bukazan. The samples were sent to FSL. The seized drugs were not destroyed by us. That is, therefore, in the whole cross part, my lord, there is nothing that the seized articles are not kept at the Malkhana, my lord. Only his cross part, my lord, he has stated I have kept in the Malkhana. Therefore, there is no suggestion, my lord. It is not kept, or it is tempered or not kept in the Malkhana. Your lordship will find from the cross part, my lord. Several times, the lengthy cross, my lord, but there is nothing, my lord. First, you have to make out a case in them there, my lord, because there you have accepted everything, my lord. So you heard.
I have not maintained any Malkhana register. I think it's working for the process. Our process.
কিবা আছে নে witness? নেদে খবৰ হ'ব।
তোমাৰ সুবিধা হ'ব দুপৰীয়া চাই দিবা তেতিয়া it's part of কিবা বিচাৰি পোৱা যায় মই এটা বস্তু দেখাই কিন্তু কোৰ্টৰ কনফিউজন দূৰ হৈ যাব
আপুনি কনফিউজ কৰি দিব
এটা বস্তু চাই লোৱা সেইটো চাই লোৱা তুমি ইনভেন্টৰীখন But regarding that inventory, let him also verify during the recess period. That is very interesting aspect, my lord. Let him verify now. As far as he's saying that the inventory they have exhibited with 25 minus. Where is that inventory? Find out.
I have not said inventory I have exhibited.
Then what I have?
He says that certificate is exhibited.
So where is that inventory, man?
That is what you said that certify the inventory.
He said that there has to be one inventory.
Certification of what?
Yet
This is your case.
This is my
Certification of what? That
I allow the above application subsection 3, 53 of the narcotic drug, psychotic substance, and hereby certify the correctness of the enclosed inventory. Where is that inventory, man?
At the second page, that has not been
No.
exhibited.
That cannot be the inventory.
No,
Because
that is not marked as exhibit.
not only that, because it has to be certified on the date which has been prepared. It has to be prepared in before the magistrate, that inventory on that day, as per the law. It has to be prepared on that day.
Everything is done.
Let me see.
Enclosed
Enclosed inventory. Now that inventory has to be prepared on 10th because the articles was produced on 10th before the magistrate. Then the inventory, the photographs, all the photographs has been taken. It has to be on 10th. Now kindly see the inventory which not been exhibited. It is on 8. Page 63. The next. It cannot be in corresponding inventory of that certificate.
Where is the date?
That is the 8th, my lord. What is? An exhibition.
No date is given.
No, that is in the top, my lord. Date of seizure.
That
That is the inventory. There's no, this is the inventory. So where is that inventory, my lord? If this is not inventory, if this is a seizure, my lord, they are saying this is not this is a seizure. This is not an inventory. If this is not inventory, there has to be one inventory on 10th. There has to be an inventory which has to be certified by the magistrate.
Name and designation of the officer preparing inventory.
Yes. And this is the name and designation of the officer preparing the inventory. And if this is not inventory, there has to be another inventory which has to be prepared on the 10th before the magistrate. Where is that inventory, my lord? This is only the photograph. Nothing, this is not an inventory. And this photograph also does not bear the signature of the magistrate. The certificate also does not been exhibited who is the signatory. But you can see the LCR, there is no inventory. Corresponding inventory. Where is the inventory?
According to him, the next page is the inventory, which is a part of the certificate, according to him.
Yes.
Is that it?
Oh, that is
his argument.
yes,
What
if
I
that
could-
is theirs, if that is his
Because
argument,
I-
this is not exhibited. He said this is not,
This
if this is an inventory supported, this is of the date of 8.
No, this is date of seizure.
This
This
is
document is bearing no date.
no date. So how this is a corresponding signet inventory
Lordship will
and
also
this,
sign.
No,
that just a minute.
That's it.
Why to clear I can argue it in the
Yeah.
next step without clarifying that.
Uh.
If you want to listen it, you can listen it.
Yes.
Otherwise, I can argue without hearing him. I can show it to the lordship.
What
If
has been
if you want to learn them, then I can show it that this is not an inventory because this is only regarding the no certificate, nothing, only a certificate.
Hmm.
But what is inventory? What is the 53 said, madam? 56 says, what is inventory?
Yes.
Lordship kindly see 52A,
Hmm.
B is very important.
Hmm.
Taking in presence of
52A,
52A certifying the correctness, that
Ah.
is the certificate.
then
Then B is more important. Taking, comma, in presence of such magistrate photograph
Hmm.
of drugs, substance, conveyance, and certifying such photograph as true.
Hmm.
There
Okay.
has to be
Hmm.
a corresponding inventory
Hmm.
certifying that photographs are true, which is not there.
Hmm.
Allowing to draw representative sample of drugs, substance in presence of the magistrate and certifying the correctness of the list of sample. So both are has to be in presence of magistrate. Then now if this is the inventory they are saying about, this is on Seizure is in 8. And this does not say about the photograph. Where is that? This has to be this
okay,
inventory.
at two. He says
Yes.
that certificate also says about the photograph and about the inventory. That is his case, what I could.
No, that
Isn't it?
no, if that is
And-
the inventory,
Uh,
the subsequent, that is the, what has been,
Hmm.
if that has to be that inventory also has to mark at the, what are the, this inventory also,
what it should contain as is prescribed in the 52
yes,
A, B, and C. Is that-
here, this inventory only says regarding my lord, soft boxes and the so-and-so grams.
Certificate for date লিখা আছে 10 কিন্তু তাতে inventory 10 নাই না certificate is dated 10
There are three.
Okay, we'll come back, we'll
I
come back.
understand, madam.
We'll come back.
Subject to correction by
Yes.
senior madam.
Yes, ASG. It will take some time.
In that case, Lordship, if it is taken up in the next week,
No, we have no problem, but
I will
where is the
inform-
petition? I have
I
to.
will inform him. I will inform him, Lordship. Next Tuesday or
Yes.
any day, Lordship. I'll inform him, Lordship.
You just give a consensus there.
Yes, I'll,
Because it's a long part hard matter.
oh, that is what I was.
Sarma,
And for the state lordship, item 19,
what about the others?
lordship. I will wait. Lordship. Okay.
Yes.
Madam, one-
No, no, you complete. You complete.
Just now, madam, from the regarding what will be the minor exact procedure minor regarding the sampling minor. I'm just going to 52A2 once more minor because
52, 1,
A2 minor.
yes. Small a.
Yeah, small 52 capital A 2 subsection 2 minor.
Hmm.
Where any narcotic drugs, psychotropic substance, controlled substance or conveyance has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under subsection 3, section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances, or conveyances containing such details relating to the description, quality. These are the for the identification matter, description, quality, mode of packing marks, identifying particulars of the drugs, or the packing in which they are packed, country of origin, and other particulars may consider it relevant to the identity of the narcotic drugs in any proceeding under this act. And now, and make an application to any magistrate for the purpose of A, B, C, 3 is there, certifying the correctness of the inventory so prepared. Here, it is not clear whether the inventory is prepared before the magistrate or
No,
on the
issue is this. What do you mean by an inventory? Inventory is
what is
that
this?
this is the what I have said, this is the quantity, this is
And this is
so
the
and so.
physical, and this is
This
the,
is the so.
yes, this is
So please certify
yeah.
it to be correct.
yes. That it be
Okay,
whether
so
the
there must be something to be certified,
yes, whether
to be
document,
correct.
yes, whether
Isn't it?
document
Yes.
and the physical quantity
Ah.
is correct or not.
Ah.
That is what the
So what Mr. Bora is arguing that where is that inventory
Yes.
which is certified to be
Yes.
correct by
Yes.
the magistrate?
that inventory in so 3 is the certifying the correctness of the inventory so prepared,
Or,
or
okay,
taking in the this comes taking in the presence of such magistrate photographs and certifying such photographs as true, allowing to draw representative samples.
so according to
Regarding
you, just let us rephrase it. According to you,
Yes,
in the present case, that photographs
where
were
in before the
taken
magistrate.
magistrate and to be true.
True. And
Now, so that certification regarding which was the exhibit for regarding photographs to be
true.
where
And
is that
PW
certification? That is according to you, the exhibit 25.
P25. P25 PW6.
Okay, what it reads?
It reads, my lord, I allow the above application under subsection 3 of section 52A of Narcotic Drugs and Psychotropic Substances Act 1985. And hereby certify the correctness of the enclosed inventory. Enclosed inventory, my lord, there is another sheet, my lord.
Okay.
In this inventory.
Okay.
And enclosed photographs taken and the list of samples drawn in my presence. A certificate is given.
So according to you,
yes,
though it is not marked as exhibit,
yes,
the inventory which is annexed with the certificate
Yes.
is the inventory.
yes, is the inventory because this is the only inventory.
Okay, now let us see
Now,
what
Lordship,
the,
they
assuming
kindly
for a
see-
moment, what
Let-
the inventory says.
Inventory says, my lord, top boxes containing heroin are packed in one cartoon box and packed with white marking cloth. This is
Can that be an inventory?
no, my lord. Sub boxes containing heroin are packed in one cartoon box.
Hmm.
My lord, that is sealed, my lord. That is not open, my lord.
Now, what is the inventory according to subsection 2?
My lord, yes, regarding the identification marks and all, my lord. I said, packed in one carton box, which Lord-
Inventory of such so and so containing such details relating to their description, quality, quantity, mode of packing, marks, number, or such other identifying particulars. Here, identifying particulars according to you, hold the box.
hold the box and my lord, signatures are there of the accused. And lastly, one thing you also may see what the language is, my lord. Or the packing country of my lord, the identification marks are given in detail.
Okay.
But it said, my lord, or and other particulars as the officer referred to.
Okay.
It is
okay,
for the
fine.
for the satisfaction of the officer, my lord.
Okay.
It is not that there.
It should be a specific.
yes,
Anyway,
no,
yes.
officer referred to in subsection 1 may consider relevant to the identity of the that is his.
So
Now, my
according
lord,
to
that
you,
is-
according to you, by the certificate subsection A, clause A,
Yes.
and clause B are satisfied.
All A, B, C are all satisfied, my lord. Inventory is before the, along with the inventory, my lord, what it says, my lord, enclosed inventory.
So
enclosed
ABC
photograph.
satisfied.
ABC is also
Satisfied.
satisfied, my lord. And the photographs that were, my lord,
Exhibited.
exhibited, and it is a part of the certificate, and that's why, my lord, as per the clause, my lord, clause 4, my 52A4.
So it is a
It is also stated
primary
that,
evidence.
yes, every court trying an offense under this act shall treat the inventory, the photographs of the drugs, psychotropic substance, controlled substance, and list of samples to be primary evidence, my lord. So it need not be, my lord, again,
Okay.
to my lord. And now,
Yes.
my lord, your lordship, just I want to refer to that photo of the photograph, my lord, where, my lord. It's one thing.
That the difference of weight,
Yes,
plastic
yes,
paper
yes.
and drugs, that you
Yes.
have taken note of.
Yes, well, that photo I could not show, man. Now I have seen. That is exhibit number P24 PW6. And these photographs are, my lord, we cannot show because it is a primary evidence, my lord. The lordship will see the weight, my lord, along with the polythene contraband, and, my lord, the weight your lordship will see 5.86 gram, my lord. This in all the, if your lordship tallies with the magistrate order, my lord, this it tallies with all this, my lord, 5.86, 5.76, all are same, my lord.
Yes.
And, my lord, again, if we tally with the, because this along with the polythene, this has been weighted, and after that it was sent for FSL, my lord, and then FSL expert says it is regarding
Less
that
4 grams
discrepancy,
and-
less, and the order reflects that the polythene weight is separately given in the order, my lord, because the polythene weight is 0.4 and something else that has been in the order, I have flag mark, my lord.
Yes.
So the regarding discrepancy, my lord,
In
there is
weight also.
nothing. Regarding the facsimile, my lord, I just forgot to point out one thing, my lord, PW page 65, my lord.
Page 65,
Yes.
page 65, yes.
FSL report, my lord, that is P9 PW5.
P9 PW5.
Here your lordship will find paragraph, second paragraph, mode in which parcel found to be packed on receipt and a description of the seal. The parcel consists of 15 exhibits enclosed in a cartoon box with seal false cover. Specimen of the seal was found to be OC Bukazan PS. That is corroborated in the statement of the, it is intact. So as per the contention as raised by my lord, the in the sampling part, just whether I could make it clear, my lord. The sampling, seizing part I have dealt with, my lord. Thereafter, my lord,
So,
sampling part also. And
52 A to C, you
A to
have
C.
answered. Now,
Main,
yes.
main crux of the, my lord.
then sampling stated not before list of sample not exhibited, that you have answered.
Yes, because discrepancy in the weight, my lord, that I have answered, my lord.
No matching of samples stated to be prepared by IU
Yes.
and sample received at FSL, you
Yes.
have answered.
Yeah, then the facsimile was there, my lord, that I have stated, my lord.
Now 52A LS seizure was not done as per provision of the act. That
That
is
is
also you have answered.
Answered, my lord.
And now contraband sample is not exhibited during trial.
Yes.
That is another
Yes, that is
argument. you have
another
made.
pen. Here, my lord, so far I have taken out some of the, some authority, my lord.
Not
where-
necessary.
Yes, my lord, I will. Yes, my lord, there is a situation where, my lord, in some cases, my
But
lord,
there is a very recent judgment, my lord Justice Oka, and very recent.
one judgment I have found, my lord, there, my lord.
Just go through it.
Yes, I, lordship may kindly.
That is 23 October 2023. special criminal number 3010 of 2023.
3010.
10 of 2023. Yusuf alias Asif versus State.
Lordship. Versus state of my lord.
It's by
Yeah.
state. It's like
Lordship,
that
yeah.
only.
Lordship.
Because some earlier decisions are discussed in this case. That's why I'm saying you just go through it.
My lord, there also the same earlier the judgments were discussed. My lord.
Just give us. Which judgment?
Lordship.
Basically on 52A, there is
Yes,
another judgment citation we'll have to find out. Mangilar versus State of Madhya Pradesh.
Yes, one.
Yes, you know, so almost their points are covered, only judgments, isn't it?
Yeah.
This was the last point.
State of one judgment I have found, my lord. It is state of Rajasthan versus Sahiram, my lord. That is there, my lord, three important judgments where it was held that the contravene not exhibited is held to be fatal, my lord. But there, my lord, certain other things are also not proved. As per those three judgments were, my lord, here
Okay.
discussed, my lord.
What are the judgments you are relying upon?
It's here, my lord, because there, what is to be, my lord, what the ratio laid down is, my lord, it is not that the non-exhibit of the entire contravene, my lord, that I have given a flag paragraph numbers, my lord.
Okay.
10, 15, 16, 17, 18. My lord.
Yes.
Before that, there are three judgments that were discussed where, my lord, regarding where contraband is not exhibited is held to be fatal, my lord. But after that, my lord,
Yes.
just I'm there are 10, my lord, just page,
At the outset.
at the
I'm
outset,
ready.
it must be considered where the cases, whether the cases relied upon by the High Court state in unequivocal terms that in case of failure to produce the contraband material before the court, the case at the prosecution is required to be discarded or not. Now, just paragraph 11 and 12 and 13 are three judgments, my lord, where because of the non-exhibit of the contravene, it was held to be fatal, my lord. But my lord, thereafter, my lord, relying on these judgments were very much discussed, and after that, my lord, may I kindly come to paragraph 15, my lord.
15.
Lordship. It is true that in all the aforesaid cases, submission was advanced on the behalf of the accused that failure to produce contraband material before the court ought to result in acquittal of the accused. However, in none of the aforesaid cases, said submission singularly weighed with this court to extend benefit of acquittal only on that ground. As is clear from decision of this court in Jitendra, apart from the aforesaid submissions, other facets of the matter also weighed with the court, which is evident from para 7 to 9 of the decision. Similarly, in Asok 4, the fact that there was no explanation where the seized substance was kept, and further there was no evidence to connect the forensic report substance were also relied upon while extending benefit in favor of accused. There, as a whole, it was discussed, not one. Similarly, in Visayan, the fact that the evidence on record did not establish the material was seized from the applicant was one of relevance. In the latest decision, again, that there was no evidence to connect forensic report with substance. Next paragraph, it is thus clear that in none of the decisions This is, my lord, what I am relying on, my lord.
Yes.
It is in none of the decisions of this court, non-production of contraband material before the court has singularly been found to be sufficient to grant the benefit of acquittal. Turning on to the facts in the present matter, the evidence of PW 15 surrender Singh shows that from and out of 7 bags of poppy hash samples weighing 500 grams were taken out of each bag. Out of these, 3,500 grams has taken out. 2 samples, 500 grams were independently sealed, while these 2 were sealed in separate pouches. These samples were marked A, B, C respectively. The bags were also independently sealed and taken in custody, and seizure memo also recorded. We have gone through the cross-examination.
You will be, your argument will be paragraph 17.
Yes, and also, my lord, I am sketching on this. We have gone through the cross-examination of the witnesses also. my lord.
Okay.
At no stage, this is important, my lord, at no stage, a suggestion, even a suggestion, was put to the witness that either the signature of the accused were taken by fraud, coercion, or misrepresentation, or that signatures were not of the accused, or that they did not understand the purport of seizure memo. It would therefore be difficult to even suggest that a seizure of contraband weighing such and such kg was not proved by the prosecution. In our view, these facts stood conclusively proved, my lord, because they are also, my lord, in the seal.
So your case is that in this case also the
Signature of the accused.
recovery is proof, signature of accused
Accused are
in the
there.
seizure list
there.
and the packet is not disputed, and
Disputed.
therefore
Also-
paragraph 7 will be applicable.
Yes, and paragraph 17, my lord. now if
Paragraph
the-
17 will be applicable.
Yes, paragraph 17, entire contraband, if the seizure material otherwise proved on record and is not
This
even
is,
doubted.
if it starts from paragraph if.
Yes,
if
if,
the-
my lord,
yes.
if the, my lord, if the seizure of the material is otherwise proved on record and is not even doubted, disputed, entire contraband material need not be placed before this court. If the seizure is otherwise not in doubt, there is no requirement that the entire material ought to be produced before the court. At times, the material could be so bulky, for instance, as is present material. Here is a case, my lord, where if the say 2 kg is, it can be, my lord. If the case is that there is a 50 kg of ganja seized, my lord. So in that case, that has been laid down, my lord. 7 bags weighing 230 kgs, that it may not be possible and feasible to produce the entire butt before the court. If the seizure is otherwise proved, what is required to prove is that samples taken from and contraband material are kept intact. And when the samples are submitted for forensic examination, seals were intact. Report of forensics, potency, nature, quality, and ingredients constituting. In the aforesaid circumstance, conclusion drawn by the High Court was completely unsustainable. The High Court erred in extending the benefit of acquittal to the respondent. We therefore allow this appeal, set aside the view taken by the High Court, restore the order of conviction as recorded by the trial court against the respondents. This is regarding the.
Okay.
So, my lord, in my submission, my lord, the non-production of the entire contraband may not be always fatal to the prosecution case and cannot be thrown away at least only on the
Yes. Yes.
on the- Now, ma'am, I go to the, my lord, regarding the interpretation of the, my lord, NDPS section, where, my lord, my learned friend also relied on the decision, my lord, where there is, my lord, the how the provisions has to be interpreted, how strictly or substantially, how it has to be, my lord, how it has to be, my lord, followed, my lord. So if, my lord, as per the one judgment, my lord, if it is a case that substantial compliance is there, that the provision, substantial compliance of the provisions is there, it will not invite, my lord, strict literal interpretation of the statutory provisions, my lord.
Okay.
That I there are 5 judgment, my lord, constitutional bench. Have given the paragraphs.
Yes.
one.
Okay. Which
Okay.
paragraph? Paragraph
Look,
3.
I have given the paragraphs.
Mhm.
3, 5, 15, 3.
We spaced my other judgment minor to read.
Which page? Just a minute.
So, I have given the another paragraph, my lord, in the top portion, my lord. Just Lord, you may go through that.
5,
Yes.
10.
So, Lord, people will find in the next
No, I've got them.
5, my lord, in the next.
Just a minute, just a minute. I'll just mark the paragraph. Yes.
For the, may I take a lawsuits? Just copy, my lord, just the 3 things, 2, 3 things I just read out. Not getting my copy, my
Okay, no issue.
here, my lord. In paragraph 3, my lord, after 1 page, my lord, after next page, that has been, my lord,
Just mark
it
it,
is clear.
mark it.
Yes,
While you read, mark it.
yes, I have made a pencil mark
Yes.
here.
Slowly read.
It is clear from Sergeant Abraham that to enforce the law under the NDPS Act strictly against the persons involved in illicit drug trafficking and drug abuse, the legislature have made some of the provisions obligatory for the purpose to comply with which the courts have interpreted to be mandatory. It is further clear that this is an order to balance the stringency for an accused by causing an obligation on the prosecution strict compliance. The court, however, while construing such provisions strictly, should not interpret them literally so as to render their compliance impossible. And it concluded that if in a case the strict following of a mandate results in delay in trapping an accused, lead the accused to escape, then prosecution case should not be thrown out. It is clear that substantial compliance has been made. It would not vitiate the prosecution case. That is the main crux I want to. And
Substantial compliance.
yes, madam, I have marked some of the, yes, Lordship has marked it, my Lordship may kindly go through, my lord. Yeah. In the advent of cellular phones and wireless services in India has assured certain expectations regarding quality, reliability, and usefulness of instantaneous messages. This paragraph, I have read, my lord. The 15 in paragraph 15, just below 4 lines I am reading, my lord. The relaxation by the legislature is evidently only to uphold the object of the act. The question of mandatory application of the provision can be answered in the light of said amendment. The non-compliance of said provision may not vitiate the trial if it does not cause any prejudice to the accused. This is the observation made by 5 judges bench decision, my lord. Another case I am relying on now. Here, man, I am relying on the evidence of, I have only one copy, man.
Just give us the.
Yes, the evidence of,
Citation.
it is, my lord, citation at, it is from Supreme Court, my lord, and Supreme, my lord.
What is the?
220. 2020.
Party's name,
Party's name, my lord, Surinder Kumar versus State of Punjab. That is.
For what purpose, Surinder?
Yeah, that is for, my lord, merely because prosecution did not examine any independent witness. If we, my lord, say that the independent witness has not supported, as my learned from the defense side that has argued, my lord, merely because prosecution did not examine any independent witnesses would not necessarily lead to conclusion that accused was falsely implicated. Evidence of official witnesses cannot be distorted and disbelieved merely on
This
account of.
is which year, judgment of which
This
year?
is 2020, madam.
Two?
2020.
Okay. Okay, read it.
Lordship has got it.
No.
No, just I'm placing 4 or 5 text, man. That from evidence on recorded case, you have to.
This Supreme Court judgment.
Supreme Court judgment. I am giving the copy, man.
Yes.
Merely because prosecution did not examine any independent witnesses would not necessarily lead to conclusion that accused was falsely implicated. Evidence of official witnesses cannot be distorted and disbelieved merely on the account of their official status. Because there, PW3, PW4, PW6, and also the scientific officer, all are official witnesses, just because if we say that 1 and 2 are not supporting each other, that though I have stated that they all have, but it has come from the defense side that they are not supporting. Even on that count also, assuming that, my lord, then we cannot discard the other 4 witnesses who are equivocally, my lord, without any contradiction, has supported the case of the prosecution, my lord. This is on this count, I have submitted this application.
Okay, give the copy.
Yes. The judgment, one sentence, the judgment of the case of Jarnail Singh versus State of Punjab relied on by the council also supports the case of prosecution. In the aforesaid judgment, this court has merely held that merely because prosecution did not examine any independent witnesses would not necessarily lead to conclusion that accused was falsely implicated. That has come from the defense that he was falsely implicated. No seizure was made. That is why, my lord, I have relied on this judgment. Another judgment I have found, my lord, that regarding the presence of the authorized officer himself in the another is 2004 5 SCC 188.
2000.
5 SCC 188. Where the officer is himself present at the place of occurrence.
Just a minute. 2000. Volume 4.
2000 volume 4 5 SCC.
Volume 4 5 SCC.
5 SCC 188.
188.
So the cases, facts are not exactly similar.
Okay, we'll see. Yes.
Yes.
Which paragraph?
Paragraph, last paragraph, 11, it's a short judgment.
Okay.
When the superintendent of police was a member of the search party and was exercising his authority under section 41, the proviso 42 was not attracted. That is.
Okay.
May I submit it?
Yes.
There is one judgment, where I have found that some observe that there are Though,
Yes.
though facts are not similar, but I am
Okay, for the
ratio,
purpose.
I am taking the ratio from the.
Yes.
And there is that 1 day delay that is
Hmm.
in the sending of the FSL quantity There is a case where there is a 40 days delay in sending the FSL the contraband but that was also held to be not fatal if other things are true.
Any citation?
Yes, it is regarding and there also the conscious position has been
No,
explained.
no, any citation?
Citation 2015 6 SC
2015,
6 SCC
6 SCC,
222.
222.
There, conscious when the conscious position is established, he here why I am saying this, because he has learned the defense side, after the conscious position is established, he had done nothing to rebut the against him, rebut the presumption against him, under section 35 and also under section 54 and DPS, that some points have been discussed here, and also paragraph 38, 39, some
Page, paragraph?
paragraph 1 is paragraph 38 and 39 regarding FSL delay.
Okay.
And also 15, 21, 20, 21, 22. Given the paragraphs in every. So perhaps I have dealt with all the points that my learned friend has been raising, If there is anything, then I can again say.
Yes, Mr. Bora, concluding remark.
Yeah, my contention is that first regarding let us read the 52A,
Just a minute. Let me arrange these papers.
Yes.
Beginning Goswami, up to yeah, like actually ambush. It is the argument. Record to the facing. Yes. We can close the files.
Yes, only just the exhibits may be the necessary,
That is
Otherwise, not necessary, my contention regarding the 52A is regarding 52A subsection 2, there are 3 types of inventory, The first inventory,
just a minute.
3 types of inventory that needs to be proved during a trial for the correctness of the seizure, sealing, forwarding regarding the custody, for the correctness of these points, But first inventory that will be prepared by the police itself in the place of occurrence. They will prepare a first inventory, whatever they have seized. Then that inventory, they will take it to the magistrate. Then you will see regarding the correctness of inventory that these are the article been seized and this is the inventory has been prepared. This is the weight, this is the substance, this is the article, whatever the inventory is prepared, he will tally with the inventory and the seizure. Then he will certify that inventory as a correct. This is the first. So that will only clarify one thing regarding the seizure and the inventory prepared regarding the seizure and the inventory on that day. On the night which the substance were seized. Only to that effect regarding the correctness of that substances which has been recovered. That is the first inventory required to be certified by a magistrate. That is the first inventory. The second inventory is more important. Then the second inventory comes, then they will prepare the photograph in presence of the magistrate. First one is not in presence of the magistrate because at it was prepared
In the place of,
in the place of occurrence. The inventory prepared at the place of occurrence that will be placed before the magistrate along with the substance. He will verify the substance along with the inventory and the seizure list. Then he will certify regarding the authenticity of that particular on that incident. Yes. That is the first inventory. The second inventory is the photograph.
in presence of the magistrate.
In presence of the magistrate, the photograph will be taken. Then he will certify those photographs. Then there will be a inventory regarding the photograph. The third one is most important is that
Sample.
the sample. Then he will prepare the list of the sample, the regarding the sampling, how it has been prepared, and the
Inventory
representative
inventory of the sampling in a sense.
sample and the representative sample also, which will be subsequently sent to the FSL. So that 3 inventory can be prepared during a process minor. 1, 2, and 3. Now here, as far as the prosecution case is concerned, where is that first inventory minor? If we go by the page 63, my lordship, this is the inventory prepared by the police actually.
By
the IO. This is not the inventory prepared in presence of the
But it says
magistrate.
itself, his signature is above that I have done this is the
Yes.
material, this is my signature.
So this is the
So therefore that contains only
yes,
the packaging and all.
packaging all, not the photograph, not the sampling,
No, nothing.
nothing. Page 63.
Yes.
But this is not also exhibited.
That is the other aspect. That is, it is not
Yes,
also.
but the first inventory, there is no inventory as such regarding on record, no exhibit as such.
So that has declared seizing authorities, the delay police, seizing officer so and so, date of seizure so and so, so place of seizure
Yes.
on national highway so and so,
This is
name and designation of the so and so. Now the details.
yes.
Narcotic dust and psychotropic
So-
substance, controlled substance and connivences.
So this is the first inventory they have prepared in the date of occurrence itself.
Then
what-
signature, initial signature is so and so, so and so.
Signature, both the signature is not exhibited, my lord. Date was not there, that inventory.
There is no date in the inventory.
Yes, there is no date in the inventory. Only date of seizure was mentioned. No date.
That is what I am saying. This is not a date of 8 date. This is a first
Yes.
inventory.
First inventory, maybe the first inventory.
Hmm.
This only certified by the
So
magistrate.
they are having this form where certification is there of date authenticity of this process, first inventory.
Yes.
That is below, but this part is not proved.
Yes, apart from that.
That certificate that which is exhibited 25, that is a general
Yes, ma'am.
kind of thing.
So I'm coming to this now. the two other rest of the inventories are also required now. The second part. For the proof of the photograph, there has to be one inventory. Then he will certify that inventory, that this is the correct inventory prepared in my presence. These are the photographs. He has to exhibit those situations, seen those photographs. He has to sign those photographs also. There is nothing. The photographs not been signed by the magistrate. No signature in the
No, no,
photograph.
that is there.
my
Judicial Magistrate First Class Bokajan Karbi Anglong scene.
No.
That is there.
Photograph, my lord.
Photographs.
Photograph is exhibited.
The exhibited photograph is seen by judicial.
Exhibited is different date, my lord.
Huh?
It was exhibited, my lord.
No, no, exhibited is before the special judge NDPS. That is exhibited. And other part is Judicial Magistrate First Class. Judicial Magistrate First Class. One is exhibited session judge 15-3, that is a different, and other is seen Judicial Magistrate First Class. All pages.
So, but the whatever.
Anyway,
Anyway, but there is no inventory to that effect. Now, now third is most important, my lord, regarding the C, my lord. Drawing, now he has to my lord, here maybe the certificate maybe. Let us see that only here, as far as the compliance is concerned, we may take a cognizance of the fact that only B has been complied with. Only B. If
Photographs.
only the photographs. Now, C is most important, my lord. Allowing to draw representative samples of such drug or substance in presence of the magistrate and certifying the correctness of the list of the samples to be drawn. That list is, where is that list?
Where is that say list of sample
No,
exhibit?
No, there is no list, my lord.
No, see, Mr. Goswami, let us not shy away from the things.
No, my lord.
Huh. Forget about for the other parts for the time being. There is a mandate because you'll have to have a sample.
Yes.
Sample is to be done in presence of magistrate and it is to be then sent to the forensic.
Yes.
Is that it? So there must be a list of sample that 15A, 15B. Yes, well, come just don't be in hurry. We have given it. No, we are not in hurry.
Yes.
So there must be something on the basis, or there must be some samples collected in presence of the magistrate, and magistrate will say, this is the list, these are the samples A1, A15, so on and so forth, which you say these are the sample which is sent to the forensic, A1 to A15. There must be a list. Where is that list?
So far, I get from the order, my lord. And the list is there in the order, but I'm just, because the list as a whole may not require, because the
No, may not require will come later on. You
Yes.
say that there was no list.
it was
However, it was reflected in the order of the magistrate.
certifying
That
the-
can
yes,
be,
certifying
your
the
argument.
correctness
We'll
of-
come to the, its reliability or not, or acceptable not, that is a
First of all,
judicial
there
part.
has to be a list. My contention is, if the list is not there, their contention is there in the order sheet. But if it was not exhibited, so if it is not exhibited, I have been deprived of cross-examination. So it has caused prejudice to me because of there's a difference of samples. So where I'll get the chance of cross-examination? Where is my rebuttal, my lord? If not, it was not produced, it was not exhibited in the document, and even the magistrate was not also examined in this case, who can testify that this is the list I have prepared on so and so date, so that I can cross-examine the magistrate regarding the correctness, the reliability of that list, my lord. And that
Okay,
list,
next, proceed.
now lordship kindly see,
Hmm.
now these only one certificate is there. in entire case, well, there's only one certificate, that is exhibit 25. Regarding only photograph, because there is no list regarding the sampling. No exhibit. A and C not being complied
No,
with.
even if we assume that exhibit, the second part, inventory A,
Yes.
small a, is a part of exhibit 25, then also so far relating the list of the sample is in terms of the certificate is also not there.
But the inventory, it cannot be valid
No,
because
just I'm saying,
Yes, yes, it
I'm
cannot-
just saying,
it's because the
suppose it's,
content does not tell you. Content does not tell you.
no,
madam.
it says that there are, the correctness of the, and they have exhibited the photo part, but not the
Yes.
inventory part.
Now,
The
the
photo part
certificate
is
also, my lord.
important, my lord, because it is a mandate
Now-
of the law, my lord.
But the second part is that Lordship kindly see the
No,
certificate
mandate
part.
of the law, see, what is the purpose of giving, preparing and giving the inventory by the seizing officer? What is the purpose? So that the magistrate, it's a process saying,
So that
Yes.
it's a saying,
Yes.
it's a saying. Suppose you see something
Yes.
and give it to the magistrate something,
Because this is
magistrate
a
will
very-
verify,
Yes.
say what you have declared to be seized and what is before me.
Yes.
Then you, okay, your
Then he
inventory is
can-
correct.
Yes.
Then he will
Certified.
now so that it is presented before him, he will have to keep a proof or for that a photograph. Then all these are there. This is assuming for a moment done. Now thereafter, he will allow to take sample in his presence, and there will be a list of sample that we have this way we have done this sample. Order is there.
Yes.
This way we have done this sample and this is the sample. It will be sent to the forensic.
Yes.
So their case is that is not there, list is not there. And if list is not there,
But
that
the
authenticity of that list, we did not have any chance to
Yes.
cross-examine
But
that.
the samples, my lord, that has been, my lord, drawn. It was again sealed in front of the, my lord, magistrate. my lord.
That's correct.
That is then again the same.
Now,
is
how,
sent
how,
to the
how,
FSL.
that, if that list is not there,
No.
if that inventory is not there,
And
where from
all-
he can say?
And all the.
No, where from he is saying
photograph.
that this is just sealed.
Yes.
If the magistrate was not examined, if the IO is silent
For
about
you
that.
and for you and me, see two aspects of the matter. For you and me, it is there in the order sheet.
Yes.
This is
And
one
all-
thing of having it somewhere and it proving or exhibiting it during the course of trial. This is the problem.
Yes, the second part. That's why the second part,
Hmm.
the number 4,
Hmm.
52,
That certification, because it will presume to be a primary evidence.
when, my lord? Lordship kindly see,
When
notwithstanding anything contained in so and so, every court trying the offense under this act, comma, shall treat the inventory. This is treat the inventory, comma, the photograph of drugs, comma, psychotropic substance, comma, controlled substance, or conveyance, or any list. This is the of sample drawn on the subsection is certified by the magistrate. So that list has to be certified. That inventory has to be certified. Not, so everything has to be certified by the magistrate.
Because it is a judicial magistrate, that's why in exception to the general rule of evidence, it has been given a status of primary evidence.
Yes,
Isn't it?
yes.
It has been given a primary evidence so that a photograph without any authentication, any
Yes.
proof is given to have primary status only on the
Without-
ground,
Without having the
only for the reason that
Yes.
it is certified to be correct by a magistrate.
magistrate.
Yes.
But that certification must appended with a list or the inventory.
No,
No.
what will be
Yes,
certified?
definitely.
What will be certified?
That's why.
Certified
Otherwise-
will be that this is the photograph.
Yes,
This is the photograph, I certify it.
yes.
This is the inventory, I
yes,
certify it.
Yes, absolutely. Otherwise, this is absolutely valid. No, not
And these
necessary.
are the list of samples,
Yes.
I certified it.
So
And
that
so
the-
that you can say in the next stage that see your list of
Yes, so
inventory
that there
prepared
cannot
before
be-
the magistrate
there
and
cannot-
which has reached the FSL is
FSL.
different.
There cannot be any doubt. So there cannot be any tampering. So that this is a very stringent legislation, madam. When the legislature is very stringent, my dear, offense is very stringent, my lord, punishment prescribed, everything has to be followed without any, my lord, Full compliance is requirement. Now, that's why, my lord, what is he certified, my lord? Even that was not also not his signature was not even exhibited, my lord. Lordship, can you see?
He has also not said that this is the signature of magistrate which I know.
Yes.
That
even
would have been,
Then, in the evidence, the PW6, what he said actually, whether he has said that these are the list. No, my lord. He simply said, I have only exhibited the certificate, no list. What he said, my lord? Page 91, he said that exhibit so are the photograph of the weighing and the marking representative samples before the so exhibit 25. That is, my lord, exhibit 25 is the certificate given by the magistrate under section 2. So only certificate has been exhibited, not any inventory, not any list. Only the certificate been exhibited. Without inventory, without list, his certificate has no use, my lord. No use, my lord. And they have not exhibited those that whatever they saw, we have been prejudiced, my lord. So there's no question of any cross-examination to that effect, my lord. Question does not arise at all. Neither the IO has exhibited those, nor the magistrate was brought in to prove that list or the inventory. And the first inventory also, the magistrate's signature was not proved. The small a inventory, that was all not been exhibited at all. So only photograph here, only that has been certified. That has been exhibited rather, without the exhibiting the signature of the magistrate. So doubt is already there that our cases matter, just to show that the doubt is there itself, because the contraband now, how it has come, my lord. On 8, he has received the information. On the night, at night, contraband is seized at the place of occurrence. 9th, again in the morning at 10 o'clock or after that, maybe it was produced. On 9th, for the first time. At that time, there's no evidence that it was under seal and seal cover, my lord. To that effect, no evidence. On 9th, when it was brought first time before the court. Then it was returned back by the magistrate. Then again brought before, again on 10th. Next day, on that night where it was kept, my lord. To that effect, no evidence. No Malkhana registered, no evidence to that effect that it was kept in the safe custody. Why should we cross-examine to that effect, my lord? It's not my burden. It is the primary burden of the prosecution.
foundational fact.
Foundation fact that it was in the safe custody. Then only I will cross-examine. Otherwise, why should I cross-examine, my lord? If the foundation fact are not there. The foundation fact is not there, my lord. Now on 9th, on 10th again, this was, the inventory was, the purported inventory had been prepared before the magistrate. Again, it was sent back. When it was, then it was again kept in the police khana. 10th, 11th.
12 it was sent.
12th it was sent to the. So again, 10th night, 11th night, 2 nights. To that effect, no evidence that it was in the sealed condition. It was in the. So regarding the preparation that the samples was in the custody, these samples were under the seal cover. Because not only the other part of the contraband, sample also needs to be in the seal cover. Apart from the rest of the.
His argument is that that it was in a seal cover is proved at the stage of the magistrate. Okay.
Yes.
And it was also proved at the level of forensic. Both are sealed with the seal condition. So therefore,
yes.
there should not be any doubt that it was. There is nothing on record to suggest
Now-
or any question that there was any break
Now,
or any leakage
they
or anything.
prove that it was in the seal cover, only simply saying will not do. They have to seal that how it has been sealed, that the cover, then the face mill, everything has to be exhibited. Because the FSL also has to receive that I have received this under the seal cover and this is the face mill. A sample of the face mill has to be forwarded along with the to the FSL, and that will come back to the court. You will compare it. Then it was yes. Then only yes, it was under the seal condition. Here, to that effect, no face meal, nothing has been seized. No, and if it was kept in the police khana, you have to exhibit the malkhana registered in the night. Where you have kept it? In your house or where? Now there is one evidence is that there are two police stations where once it was received by the one police station, then subsequently this next police station, which is far away from that, one is from the Bukajan, first is Dilai, then second one is Bokajan. Two different police stations. Contraband has been found, not in the same police station. How it has traveled from one police station to second police station, there is no answer from the prosecution, madam. So there is always a doubt. Now, now apart from that, there is no forwarding to the FSL, madam, which is very fatal. Because forwarding necessary so that what sample has given to the FSL, madam, and what has come back,
And
that
what
has
has
to be
been,
televised.
what is received?
What is received. And these are not there then when there is a doubt already been created, my lord, when it has become fatal, when you have not even exhibited the original contraband itself. Otherwise, it may not be so fatal, my lord, to place all the contraband, my lord, before the court. But here, it is only the 2 grams. 2 kilograms. It could have been, my lord. Why it was not produced before the court, my lord? The rest of the part, not even the rest of the part. That is the remnants part I'm talking. Now, regarding, my lord, the compliance of 42, my lord.
Okay.
Now, the 42 requires two parts, my lord.
Mm.
First of that, if the person is authorized himself and he has got some secret information, my lord, he is authorized otherwise. But if he has to, that information he has to reduce into writing, my lord, first of all, the secret information. If he is authorized, then also, my lord, what he has to do, if he goes for search and seizure after the sunset, my lord, then he has to procure a warrant. He is authorized officer. But here, so without warrant, he can proceed, provided he has to give a reason. Here, absolutely no reason. The exhibited, they have, whatever they have exhibited, my lord, the GD entry, there is a doubt of the GD entry itself, my lord. There are two GD entry. Now, it says, my lord, provided further that if such officer, that means the authorized officer, has reason to believe that such warrant or authorization, he is already authorized, so warrant cannot be obtained without affording opportunity for concealment of evidence or facility for the escape of the offender, he may enter in the search the building of the convent's enclosed place at any time between sunset and sunrise after recording the grounds of his belief. So where is that grounds of belief, my lord? In this case, my lord. Now, if we go by that, my lord, the GD entry, that is my GD entry number 162, there is no grounds of belief, my lord.
You have given that that note. We have already, you have argued all those.
Yes.
You have given those notes. No, you need not repeat, just you answer.
Now the second part is that he said that there is no need. The second part is that, after that also, he has to forward that with his immediate superior officer within 72 hours, my lord. Here also that part is not complied with, not even the partial compliance, my lord.
Okay.
There is total non-compliance, my lord. I am in total non-compliance, my lord. Now he says, my lord, there is an authorized officer himself is carried out the search and seizure, my lord. She was also present, probably. Now, to that effect, I am relying on one judgment, my lord. Already I have given the
You have
copy.
given, those are there.
Yes, in that judgment also, there is an authorized officer, KL Meena. The judgment of my lord, that lordship will find that the Babu Chakraborty's case.
Yes.
Yes, in the Babu Chakraborty's case, the superintendent of police was himself along with the seizing officer. Even then, Supreme Court says, no, 42 is mandatory. That reason, non-procurement of the warrant, my lord, that has to be given. And this second part also, grounds why he has failed to comply with, that has to be there, my lord. The Babu Chakraborty's case, my lord. So that the only that because of the one superior officer is present during the search, that will not the compliance of the 42. 42 compliance is totally different, my lord. Whoever may be, because even the authorized officer is also authorized.
According to you, this is not relatable only to authorization.
Yes.
Even
Yes.
the authorized officer is
Yes.
to follow the
Yes,
mandate of
ma'am.
authority. This is your
Yes,
argument.
yes, ma'am. Because that is the success. Because it says, my lord, if such officer, that means the authorized officer, prior to entering, my lord, that has to be prior, my lord.
Whether he delegates or he does himself,
Yes.
according to you, the mandate that 42 is to be strictly followed.
Yes.
And
So these are the my.
Babu Chakraborty will-
So my lord, his argument is that we have not cross-examined, my lord. Why should I cross-examine? If the prosecution is itself is silent regarding the seizing part, my lord. There's no need for me. If the doubt is created in the prosecution story itself, there's no need for me to rebut it, my lord.
So according to you, without any cross-examination also, the
I can rebut the-
prosecution is to
Yes,
place their
that
at
is
least
the
their
law, my lord.
foundational case.
Abdul Rahim, there's a one case, my lord, Abdul Rahim. That is the Supreme Court has categorically said that the how to rebut a presumption. My lord. Yes, presumption is available in the act. But that presumption is not absolute presumption, my lord. Always a rebuttable presumption. But how can I rebut? I can.
Therefore, to come to that situation, the law is that you will have to lay the foundational facts of your case.
Yes.
Then only onus you will have to
Yes.
establish the foundation.
Yes. So when there is no inventory prepared by the police itself.
So you have not laid the foundation that it was properly done.
Yes, it was properly seized. It was properly placed before the magistrate. What they are saying that it was a seized condition magistrate has seen. Where from they have come to the knowledge? From the inventory. But that inventory was not exhibited. There is no inventory to that effect. Inventory will say that it was in the seized condition. The magistrate will certify that I have found in so and so. That inventory will say that this was in the sealed condition, these are these. But there is no inventory to that such effect, my lord. 52 small a. Not even a whisper from neither the IO has also clarified that I have complied with, these are the provision I have complied with, that I have kept those articles seized, then sealed it, then I have placed it before the magistrate on so and so date, then I have again taken to my Malkhana in the sealed condition, again I have brought it back to the court under the sealed condition, then I have opened the seal, then I have prepared the inventory, taken the photograph, prepared the list of the sample, sealed it, remnants as well as the corresponding articles. Then I have forwarded with a forwarding, absolutely silent man. That's all,
Anything?
man.
That's okay.
5 minutes, madam.
Yes.
Regarding 42, my lord, I have made my submission.
Yes.
I will not repeat what.
No,
my
no,
lord.
not this, not it.
And regarding the, my lord, inventory part, my lord, I couldn't, my lord, find out from where, my lord, it is stated that there are 3 types of inventories are required, my lord. If we go by the section 52A2, my lord, it is said that, my lord, the language is very clear, my lord. The controlled substances, and my lord, your lordship will find that only the police, the seizing officer has prepared the, your lordship will find where any substance has been seized and forwarded to the officer in charge of nearest police station or other officer empowered under this subsection 1 shall prepare an inventory of such narcotic drugs. That is only has prepared an inventory, and that inventory along with the samples, along with an applications has to be submitted before the magistrate, my lord. And magistrate will, my lord, see whether the inventory and the physical contraband is the same or not, my lord. This is what the.
No,
the
that
law
is not the issue. Issue is what he is arguing is this inventory, photographs and list of representative samples
No, my
to
lord.
get a status of primary evidence need to be certified by a magistrate in terms of
No, my-
subsection 4. Until and unless that is there,
No.
this
That
will
is
not
what-
be admissible as an evidence.
That is what I'm saying.
Primary evidence. This
It-
is his case.
Yes. That is what I'm saying, my lord. The lordship may kindly see that section 4, my lord. Read the inventory, one part. The photographs, another
Second
part,
part.
and samples.
Third part.
List.
Samples.
Not
List
only
of
samples,
samples.
list of samples.
List of samples.
Don't have. Now, my lord, it is not that the inventory has to be prepared once and again
No,
before
that
the.
is not the issue.
Yes.
See, you want to prove a case
Yes.
through a evidence.
Yes,
What is that evidence?
Yes.
Evidence is a inventory.
Yes.
Not anything else.
yes.
That inventory will testify certain things.
Yes.
That inventory in the otherwise or photograph
Yes.
or list of the things
Yes.
is otherwise not an admissible evidence in terms of the Evidence Act.
Yes.
Notwithstanding anything contained in the Evidence Act,
Yes.
it can be treated as a primary evidence provided those materials,
Yes.
those particulars
Yes.
are certified by a magistrate.
Yes.
So one part is the certificate and
Yes.
other part is the certificate is not the primary evidence.
Yes.
Certificate is a certificate which says these are the primary evidence.
Yes.
So your evidence are of 3 kinds. One is the inventory, second is the photograph, third is
Now-
the list of
Yes.
things, samples.
Yes.
Where are those evidence? That's all.
There-
Then we'll come to the provision that
That
this is
why
the
I'm saying
certificate.
There are 3, my lord, your lordship will have photographs.
Hmm.
Photographs is, my lord.
Yes, I have
exhibited-
seen that.
Exhibited, your lordship may
Yes,
kindly note.
yes.
Photographs are exhibited as P11 to P6.
Yes.
These are representative samples, my lord.
Mm.
These are not other photographs, my lord.
Mm.
The photographs as a whole and also representative samples of 15 lot.
Mm.
These are exhibited as PW.
So you want to say when photographs are given, no separate list of sample is necessary.
Yes,
If
that
you want
is
to
not-
say that is different
That
issue.
is-
Then
is-
why did it,
Because the.
why
No.
CNC, my lord?
Huh?
Then the why
Because
CNC come, my lord?
what has
If
come from the
photograph is-
photographs, just I am seeing the exhibits, my lord. The photographs are weighing and marking of representative samples before
No,
the learned.
suppose just answer
Yeah.
one question. We understand you.
Yeah.
You answer one question. Now, along with the sample, what will go to the forensic?
Yes. Now, yes,
That these are the samples collected. There
A-
must be a list.
a forwarding, I
That
just.
this has to be there, my lord. The photograph, otherwise, C is
I-
not required itself. If the photograph
I-
itself is, can be a,
No, photographs may not be required if they do not rely on that. That is their primary evidence.
That is a
Because
primary-
they may file an application to say that please treat this to be a primary evidence. That is my understanding.
Yes,
Yes.
but that's why they have taken the photograph
Hmm.
and prepared it.
To use
and-
it as an evidence.
To use
But
it as-
they can use it as a
And-
evidence, as a primary evidence when this is certified by a magistrate.
Yes,
And certain things are done, that this
Ye-
is done before me.
yes. So here, my lord, apart from the photograph, where is that other 2 inventory, my lord? The inventory, first inventory under A. Where is that inventory, my lord? Where is that exhibit, my lord? The first inventory which is prepared by the police under subsection 52, subsection 2, where is that inventory, my lord? First inventory.
Where is that
Anyway.
inventory?
And also, my lord, regarding the face meal, my lord,
Hmm.
it is, I have just, making refreshing, my lord, that I have stated in the evidence of the FSL expert and also the FSL report that has been annexed, my lord. There, the face meal of the seal was found to be OC. That part is
Found to be,
there.
my lord. That has to be
That-
exhibited again.
That has to be there, that is there, my lord.
That
That is
too
one
has
part.
smell, my lord.
That is one is there. And another thing, my lord, আরো কি কইছিল আপনি?
It is not as such a procedure. It is a certification, authentication of certain material or uplifting certain material to be a higher standard of or primary evidence. Because it says if he may file an application, he may not file an application, he may do something else, he may bring primary evidence,
And
other
your-
primary evidence.
Fine, my lord, in the FSL report, my lord, the forward it is said your memo number such and such advising the examination of parcel per messenger. That is the forwarding to the
Exhibit number, exhibit number.
No, not exhibit. my lord.
That
It
is, that's
this
what I'm saying.
This is from the
That
exhibit
is, where is the
of-
forwarding?
of the, my lord.
Where is that forwarding?
Okay, list this
What are not
matter
there?
for on 2nd of
And-
August. Hearing is
Yes.
concluded.
And another,
List this matter of 2nd of August. In the meantime, parties may given. No, please stop. Mr. Bhagavati has already submitted a written note of argument.
I will give it-
Mr. Goswami may file the same on 2nd.
yes.
And they may also add anything to be added. That's why I'm keeping a one day for you. You just, if you.
That's a notification regarding 456, my lord. Regarding 52A.
That's, in some judgments I have got
Yes,
it, there is a
Okay.
This is
notification.
the notification.
I give that, I was searching for.
এখন বহুত পুরানা
Dated.
notification.
In some Supreme Court judgment, there is
Yes,
a
yes, it is
reference of that
reflected, yes.
notification.
That is very important, my lord. It is.
There are some notifications I found in some Supreme Court judgments.
23rd.
In fact, I think there
Ah, got it.
notifications are quoted in those judgments.
Yes.
I have just given those judgments, recent judgment.
My lord. Here, my lord, just I want to, one thing clear, my lord. The rules, the notification has now become a rule, my lord, as 2022 sampling rules are there. my lord. This has come
When?
in the year December 2022.
The
So
previous,
this is prior.
This is prior.
There are long back, there are some notifications.
There are prior and there are some notifications. Mr. Bhagavati, I have said to two judgments, na? So I don't have the citations. In one of the judgments that in one paragraph that things are quoted.
Because
And the rules along with this notification is there, my lord. The rules itself is appended with the notification.
an FIR is
In
of,
the-
my lord, 9/5/22. And the rules has come on December 22.
Keep it by slip,
Yes,
most of
yes,
it.
yes.
by slip.
There are prior notifications also, how this 52 has to be complied with.
Next. Second, we'll try, or if not possible, yes, what is this course?
Maternal death case, lordship. As per the last order of this honorable court,
Where is Mr. Sharma?
yes, lordship, as per the last order, board, a report has to be submitted by the health services to constitute a
This
committee.
matter should be listed in orders column instead
Yes,
of
lordship,
hearing.
yes, lordship. It should have been in.
I'll direct it to be listed in the order column.
Yes. lordship.
Yes, report.
Lordship, it's still awaited, Lordship. Actually, a lot
We
of time
cannot
has
wait.
passed.
You can wait.
Lordship.
It's a judicial order.
Lordship, I understand. from them, we have communicated to them regarding this, that a particular committee has to be made with gynecologists and all, as stated in the order itself. But till
Now,
now,
who will give us if they do not even, if they
we'll
do,
send another reminder.
if they ignore you,
Lordship.
we'll call them here.
Lordship may give us one last
If
opportunity.
they ignore their lawyers, we'll call them here. As simple as that. Isn't it?
Lordship. Lordship may give us one last opportunity, we will communicate accordingly.
You are Mr.
M. Huya, Lordship.
M. Huya, learned standing counsel
No,
for
I'm not standing. counsel.
Huya, appearing on behalf of Mr. B. Gogoi, B.
Gogoi.
Gogoi, learned standing counsel for the health departments. Praise for 2 weeks accommodation to submit the report in terms of this court's order dated 27 to 2024. Full stop. Prayer is allowed. List this matter on 3rd week last part. Almost we are giving you 3 weeks.
Thank
Okay?
you, Lordship.
22nd of August 2024. Registry to list this case in the order column.
Deep level. 19.
None appears for the petitioner on call.
My lord, I am appearing on behalf of the respondent number 1 and 2, my lord.
Okay.
What and above, my lord, that this is a second petition in respect of the same subject matter. The earlier petition was withdrawn, my lord. Then again, this as a second petition is filed in respect of the same subject matter.
Yes, Mr.
The senior counsel is appearing for respondent 1 and 2, your lordship. This is the second round of litigation. The challenging judgment passed by the London District Judge, your lordship, seeking enhancement of the compensation.
We'll dismiss this. Let them come fresh for restoration.
Item 19.
Yes, anybody appearing? Item 19? No. None appears for the petitioner on call. Though Mr. NC does learn a senior counsel representing
1 and 2, your lordship.
respondent number 1 and 2 is present virtually. First up, Mr. Ish Sharma is present representing
The state lordship.
representing the state respondents. Full stop.
Must be respondent number 3, your lordship.
Yes, lordship. Respondent number 3.
Respondent 3.
To order to 11-5. Pencil to pencil. Okay. Comma. Be that as it may. On earlier occasions also, the learned counsel for the petitioner submitted before this court that he has no was granted on the earlier occasion, that is on 24/6/2024, the learned counsel was granted time to obtain instruction from his client as the matter is obtained the instruction from his client. Full stop. Be that as it may, as none appears for the petitioner on call, this writ petition stands dismissed for non-prosecution. Interim orders, if any, stands validated.
Oblige, your lordship.
Oblige, your lordship.
20.
Yes, what is this?
May I please, your lordship? My lord, in this matter, my lord, I recently filed the Ukalatam in this case. I have prepared the matter method, and matter pertains to my lord. The allotment of khas land for special cultivation of tea and rubber tea. In this case, my lord, 1992, my lord, we are in possession, my lord, with a registered society, my lord, and thereafter, my lord, time to time, deputy commissioner, settlement officers conducted inquiry. Ultimately, the submitted report in my favor, my lord. All the reports, even if it filed deputy commissioner before this court, they have stayed, my lord, in my favor, my lord. But they're dealing in this matter, my lord, to approved. For approval delaying, I am approached before this honorable court, my lord. Lordship, can
Now
you have
tell us, can we issue a writ to that settle in favor of this? person.
Already saw all the got report direction, all in my favor. They waited, my lord. Just because of not doing direction, my lord, for mandamus we are before this court.
No, no. We understand.
Yes.
You are seeking a mandamus.
Yes.
Now,
No, Lordship cannot say Lordship I directed instead of keeping delay the matter.
consider this
Yes,
case and
yes,
dispose
yes,
it of. That's
yes,
all.
yes.
Not beyond that.
Yes, Lordship, only 4 days, my lord.
We'll just record what is their stand and
Yes.
what is your case.
Yes, my lord.
And we'll say that
Yes,
in
yes,
view of the
absolutely.
aforesaid decisions,
Absolutely, my lord.
let the
Yes,
competent authority take a call on the
Time bound direction may be given.
within a period of 8 weeks or.
Before SDLC, my lord.
Yes, my lord. All
Deputy
agency
co-
already report delay in favor.
I don't know that.
So we cannot direct to place before SDLC.
Yes, my lord.
We'll say whatever is required for consideration, they will proceed in
Yes,
application.
yes. Deputy Commissioner may place it before the SDLC, then it's sent back to.
We'll say the deputy commissioner.
Yes, madam.
How deputy commissioner will do, will not say.
Yeah, deputy
Eh,
commissioner sufficient.
Deputy commissioner, if it may be needed, SDLC, it may be necessary, some permission from the revenue, different things are there. We are not going there.
Yes,
Madam.
Suppose it's a land for suppose special cultivation and all, there are some other procedures. We
Right.
cannot straight away say that it listed before since. Third, Mr. Dekha, learned counsel for the petitioner. Orders. Tea land cannot be, special cultivation cannot be created in this way. Difficult. Maybe they might file affidavit. Petitioner is a society, isn't it?
Yes, my lord.
Registered.
Society, my lord. In the name
A
is.
petitioner is a society registered under Cooperative Societies Act.
My lord.
Full stop. The petitioner claims, the petitioner claims that it is in possession of 1200 bighas of government khas land covered by Dag number 1 of village Mohammadpur since 1992. Full stop. According to the petitioner, the said land is fit for cultivation of tea and rubber. Accordingly, a proposal was sent to the government. No, full stop. Full stop. The assistant settlement officer, Udarban Revenue Circle, Silsar, also submitted a report along with a communication dated 10/3/2014 addressed to the Deputy Commissioner Kachar, opining that the said hillock covering more or less 1200 bighas of land under second RS Dag number 1 under Mouza Muhammadpur of Udarbanda Revenue Circle is fit for special cultivation like tea/rubber plantation. Full stop. The case of the petitioner is that even after such recommendation and opinion of the settlement officer, nothing has been done till date for allotment of the said land in favor of the petitioner by the competent authorities. Full stop. Any affidavit file?
Yes, my lord.
What is their stand?
My lord,
Deputy Commissioner?
my lord, yes, my lord. Deputy Commissioner, my lord, reported the settlement officer report, my lord. Kindly have a look. Page
Yes.
55, my lord.
Page 55.
Yes, respondent number 4 has filed affidavit. In the respondent's file affidavit opposition, my lord. Page 55, annexure 1.
The respondent number,
Deputy Commissioner, respondent 4, my lord.
the respondent number 4 has also filed an affidavit in the present writ proceeding
Paragraph 4 stated details fact.
and took a stand that the proposal for allotment of the land in question was sent to the government in revenue and disaster management within bracket settlement department on 29/4/2015.
My lord.
15 and the said proposal was placed before the state level land advisory committee and the said committee in its meeting held on 18/11/1992 1992 resolved to authorize the Deputy Commissioner, Kansar to approve the proposal if the society is found to be a registered organization with a condition that no proposal for allotment in case of individual should be considered. Proposal. And who else has filed?
Respond number 1, my lord, Revenue Department.
Revenue Department. Huh?
We
Revenue
have filed
Department.
affidavit, small affidavit, my lord.
Where is that?
8823, my lord.
Page 8823 by what is the name?
Dipankar.
Dipankar Das.
My lord. Page 68, my lord, annexure A.
Dipankar Das.
Yes, ma'am.
What is that affidavit?
But you have to submit the report of the settlement officer has to submit before SDLC. Thereafter to competent authority, my lord. Forwarded to competent authority, my lord.
Full stop. The what is his designation?
Deputy Secretary, my lord.
The Deputy Secretary of the Revenue and Disaster Management Department has filed an affidavit and filed an affidavit to whereby a stand has been taken that a certain procedure is to be followed for allotment of the land in terms of the extent land policy. According to the aforesaid affidavit, the SDLAC is to make recommendations strictly and in accordance with the land policy, and it should be And thereafter, it should be placed before the competent authority to take a decision on allotment of land as per land policy. Full stop. Since the land policy, in the aforesaid backdrop, this court is of the considered opinion that no writ of mandamus can be issued directing settlement of the land in favor of the petition, inasmuch as such settlement shall depend upon the extent, norms, and land policy of the state. Full stop. The original recommendation of SDLAC relates back to the year 1992, and in the meantime, there are changes in the land policy of the government. Therefore, at this stage, this court is of the view that the entire matter can be disposed of, relegating to the matter to the secretary of the commissioner and secretary to the land and revenue and
Am I not principal secretary?
principal secretary,
Revenue
revenue
disaster-
and disaster management department to take a call on the application of the petitioner so far relating to the settlement of the land. Full stop. Accordingly, it is directed that the case of the petitioners be considered by the aforesaid authority in terms of the extent, norms, and policy and the procedure of the state. Full stop. State of the such exercise be carried out within a period of 8 weeks from the date of receipt of a certified copy of this order to be furnished by the petitioner before the principal secretary, revenue and disaster management department. Full stop. While parting with this record, it is made clear that this court has not opined anything on the merit of the claim or claim of the petitioner or of the state. Full stop. The claim of the petitioner be considered in terms of the extent, norms, without being influenced by any of the orders, any of the state, any of the any of the comments made in this order.
One more, Milord, I have to talk now. Deputy Commissioner also may be directed to.
No. That is gone under this 1992. Deputy Commissioner will simply say High Court has give it 1200 bigas. Those are not the days.
I'm really sorry, my item number 19, my lord. Any other date, my lord.
What remains in a
This is-
petition?
No. Actually, my lord, they did not pay anything against land, my lord. Only surface damage they have paid, my lord.
You can get only surface only.
No, my lord,
Under Telegraph Act.
There are some, I have gone through. some-
Under the Telegraph Act, you get for the surface only.
There are some subsequent development also. I have gone through this some orders, my lord. They have paid that they will be, my lord, again land also, my lord, they will get some, my lord.
You don't get land because these are under what is that provision? Is land taken for what purpose?
My lord, for high tension.
High tension
Yes,
wire. These are taken under Telegraph Act.
Telegraph Act.
And Telegraph Act, there is no provision of payment of land compensation.
My lord,
You can keep this alive for few more days.
Well, next week, my lord.
What is your instruction? You have asked on the last occasion that you have don't have any.
Yes, just mobile number, my lord. That is why, my lord.
So that we have dismissed, you inform that.
No, my lord. Only any other date, my lord.
No.
Next week, my
We have
lord.
already dismissed. You file an application. Let us see whether they comes or not.
Kindly, my lord.
No.
What happened, my lord? Actually, I was whole day in the first half, my lord. In the second half, I went to the old building, my lord. So I was following the, my lord, display, my lord. And
That
suddenly,
can be a good ground for restoration.
my lord, suddenly came to
If
19.
just write it and file an affidavit, then we will know. Then we will know that you have a relation with your client.
Because, my lord, I some adverse, my lord. Kindly.
You have a talk with Mr. Das.
Next week, my lord. Kindly, my lord.
Nothing is
My
there.
lord, last date also, my lord, I never, my lord, I had a.
Forget about the information of your client. Tell us about the
My lord,
provision of law.
My lord, I talk some other person, my lord, they will inform him, my lord. And I have to ask them to collect mobile number, present mobile number.
They will not advise you on law. You enlighten us on law. Facts are admitted that
Because, my lord,
high tension line has gone,
Some of the locality, they are getting, they have already got some higher
We do
benefit.
not know. We know the law.
Right.
You will have to show the provision that under electricity, Telegraph Act, this is entitled, you are entitled.
But I'll show
Yes,
it.
sir, good.
Next week. Well.
Give a date after 2 weeks. Before Das informs his client and is in a awkward position, inform him first. He's an official client. Inform, go and inform us. Then only tell her,
I'll inform.
then only I'll recall.
Well, I'll inform.
You have time till 4,
Well, I'll.
4:15. After that, orders will be online.
Well.